2 o'clock now. Good day,
Recording in
honorable
progress.
ladies and gentlemen. Can you give us at least 2 minutes to allow others that are struggling to log in? Then we will continue with our meeting. Just 2 minutes.
Okay.
I think they have managed to settle and they have managed to log in, if I'm not mistaken. Today's network is very, very bad. I am not going to waste any time because we are dealing with an important issues today. So try, if others are not, they're still trying to log in, they will find us on our way. Honorable members and ladies and gentlemen, let me take this opportunity to welcome you to this meeting. I'm aware that we have been busy for the whole day. We had a plenary today. Some of you are so exhausted, but this meeting is very key, it's very important because we are dealing with the bills, which is our mandate as the honorable members. And to say these bills are very key and important. When you look at this time, you'll find that this fire Veld is so dangerous in our country, which is killing people, which is killing our animals. I think it's affecting both the Department of Environment, Department of Agriculture, because when you talk about the animals, it's Department of Agriculture. When you talk about the fires, it's for Department of Environment. So I think, honorable members, when we get to this meeting, when you deal with those bills, you'll deal with it bearing in your mind that these bills is key to our communities. Like I said, when during this period, there is a fire Veld that is killing I think in my province, in particular in my province, it's almost killing more than 300 sheep and goats, and about 6 people has lost their lives. And in other provinces like your Free State, also it kills, or not only those two, even the grazing area. Our animals, cattle, and so on, they don't have a grazing, they don't have grass for grazing because it was damaged by the fire Veld. So that's why I'm saying this bill, honorable members, we must put aside our political caps and so on, deal with this bill because it's important. By so saying, honorable members, I was just welcoming everybody, welcoming the department, both Department of Agriculture, Department of Environment, which are in the meeting, that are going to respond to the issues that was raised by our communities. So you are welcome. And if the members from the provinces are also in the meeting, as usual, honorable members, feel free to participate in this meeting. Feel free to raise any important issues, because that issue you are raising is gonna assist us as the National Council of Provinces to make sure that this bill it cover all the provinces, and it represent the interest of our communities. Thank you. Not going to waste any time. Just going to check with you, Aska, whether are we cooperating in this meeting, because we cannot continue with the meeting if we are not cooperating, because we are going to vote.
Thank you, Chairperson. Chairperson, for today's purposes, we have 2 quorums. The first quorum is to continue with the meeting, which we do correct, but we do not have a quorum as yet when it comes to voting. So I'm still waiting. I've already sent messages, and I'm waiting for 1 or 2 members who have voting powers to enter the platform. But if we have special delegates from provinces, if we have a special delegate from Mpumalanga, Gauteng, Limpopo, then we may proceed. If we have special delegates from those provinces, because obviously in the absence of the permanent delegate, the special delegate has the voting power. Thank you, Chair.
In the meantime, Askam, can you quick call those members direct? Don't send the messages.
Will do. I'm busy as we speak, Chair.
Okay. But you said for continuing with the meeting, we are cooperating.
We have 5 provinces present, so we can continue with the meeting, but we just cannot take any voting decisions yet.
Okay. Okay. Honorable members and ladies and gentlemen, because the purpose of this meeting is to vote for those mandates, I plead and request you to just wait for at least another It's now the time is 11 minutes on. Tatem Kiva have joined. I think we short with how many? One or how many? And very soon, I
One
think.
member, Chair.
Yeah. Can we try Honorable House Chair, because she was sharing the session today, Honorable Ngwenya, so that she can join. And Mamu Kausa, and also Mamu Kausa, she must be in the meeting because also she is a voting delegate, or unless there is someone from Northern Cape.
Chair, Ms. McCall says online, so we now have a quorum.
We have quorum.
Yes, Chair.
Okay. I'm told we have the delegation from the department, both Department of Environment and Department of Agriculture. But we will start with the Department of Agriculture, because this meeting was supposed to be held last week. But unfortunately, because of the quorum, we couldn't do that. Now, that's why we put two bills at the same time today. So we are going to start with the Department of Agriculture, and I mean the bill, which is agricultural. Is it agricultural product? Yes. Bill. But before that, Aska, can we explain the process? How are we going to handle this?
Thank you, Chair. Chair, what we'll do is we'll start off with the Agricultural Products Amendment Bill. We'll go province by province in order. Eastern Cape, Free State, Gauteng. Cobus will read out the mandates. He will read out each clause. Once he's read out a clause, we will vote on that clause. I will then call out the province. I'll say Eastern Cape, then Free State, Gauteng, and a member from that province either has to say, I support, don't support, or abstain. So we'll do that for every clause on every mandate. I'll run through it again. Cobus will start off by reading. You'll start off with the Eastern Cape. You will read the first clause as it should be read. Once it's done, the department members, law advisors can interact, ask questions. Once all that is done, I will then come in and we will vote. I will call out each province and the member of that province. The voting member of that province will say support, not support, or abstain. For the Eastern Cape, that member is Mr. Mkiva. For the Free State, it's Mr. Nsube. For Gauteng, it's Mamgwenya. For KZN, it's Mambibi. For Limpopo, it's Mr. Mamrubela. Pumalanga is Mr. Nyambi. Northern Cape is Ms. Bukause. Northwest is Ms. Budise. And Western Cape is Ms. Labuskagni. Thank you, Chair. Chair, I'm handing it back to you. Thank you.
Chair,
Chairperson,
Chairperson, it's Kathy Labuskaghni speaking.
I think she's having a bit of a network issue. Give her a few minutes. Thank you.
Pascal, can I ask you directly, on what date did you send the mandates? Because I'm trying to find my mandates. I know that I've got them, but if you can just help me, if you can remember the dates that you sent it.
I'll have to go through my mail. I sent it a while ago because Western Cape sent theirs quite some time back. Do you want me to forward you the mandates again?
If it's not too much of a trouble, I would really appreciate
No.
it.
I'll do it right now.
Thank you.
I'll send both.
Okay. Hey, today's network is very, very bad. Mine, Bibi, if it happened that I get out of the meeting, please, you must continue with the chairing. Yes, honorable members, now we can continue with our meeting. Can we start with the oh, by the way, do we have any apologies before we go there?
Yeah, I did not receive any apologies from the members. I think the department should mention this if they have any. Thank you.
Okay. Members, do you have any apology for someone? For other members? None. Let me go to the Department of Agriculture and Reform. Department, do you have any apology on your side?
No, Mr. General, no, Chairperson. We don't have any apology that has been advanced to ourselves.
Okay. I don't know, Aska, whether the Department of Environment are in the platform. Let me check with them because apparently they will join at past or somewhere there. Department of Environment, do you have any apology from your side?
I don't think environment's on the platform yet, Chair.
Okay. No, it's fine. Can we start now? We start with the, what do you call it? The mandate from Eastern Cape.
Oscar, can you perhaps give me screen sharing permissions? I do not have it at present.
Eastern Cape present, Honorable Chair.
Oh, you're welcome, honorable member. It's honorable.
Bese.
I represent.
Oh, Dr. Bese.
Yes.
Oh, Dr. Bese.
Yes, ma'am. Yes, Honorable Chair.
Oh, you're welcome. Okay.
Yeah. I'll be reading the Honorable Chair the negotiating mandate for the Eastern Cape. The name of the bill is the Agricultural Product Standard Amendment Bill. However, the vote of the Eastern Cape, the province votes in favor of the bill with proposed amendments, and therefore mandates the permanent delegates to the NCOP to negotiate in favor of the bill within the following parameters. The proposed amendment bill are as follows. Clause 2 of the bill, amendment of Section 2 of Act 119 of 1990, as amended by Section 2 of Act 63 of 1998. That Clause 2 be amended as follows, Honorable Chair. A, the Minister may, for the purposes of the application of this Act or certain provision thereof, with regard to a particular product, designate any person, undertaking, body, institution, association, or body having particular knowledge in respect of the product concerned, as an assignee in respect of that product, designate in the consultation with relevant stakeholders directly involved in the product concerned, as the assignee a person, undertaking, body, institution, association, or board, having a particular knowledge on the product concerned, or having a particular knowledge of the relevant management control systems, with no direct or indirect personal or financial interest. That's clause 2, Honorable Chair. I don't know whether I must continue with clause 3. May I get an indulgence from you?
Chairperson, the process is now that we've finished the one clause for Eastern Cape. The members may engage the department and the legal advisors, then we'll vote on that clause, and then we'll move on to the next clause of Eastern Cape and do the same. Chair, thank you.
No, thank you.
Thank you.
Honorable members, you can engage, and then from the department. And I'll call the legal the legal advisors to assist after that. Members, do you have anything, any comment on this clause? So nothing. Let me call the legal advisors. First from Parliament and then state law and all these categories.
Chair,
The legal advisor. Hello. Hello. I heard someone was talking.
it's going to be long.
Honorable.
Chairperson, that's Honorable Abiskahni. Can we move the page just a little bit more up?
Okay.
Is there a two as well, or is it just A1? Does it stop? Does this proposals of these two as well and a B? Okay. Okay. Thank you.
Okay. Department.
Thank you, Chairperson. I think with due respect, the change that has been advanced seems to meditate against the very objective that the minister sought to remedy by objectively designating assignee without any influence from the relevant stakeholders. And the question is, who are the relevant stakeholders in the main? Because the criteria that has actually been set out in the bill itself, that gives directions to the minister as to the kind of people who are to be appointed. And those kind of people should actually be the kind of people who have the requisite knowledge in the product concerned, having the particular knowledge of relevant management control system, and of course, having no direct or indirect personal or financial interest. Now, if you are to say that the minister has to appoint or designate assignee in consultation with relevant stakeholders, that itself brings about conflict, which is what we wanted to steer clear of by actually drafting the text in the manner that we did as proposed in the bill itself. So much as we understand precisely as to what it is that the Eastern Cape provincial legislature wants to steer to, but we think that will certainly be defeating the very same purpose of trying to appoint an assignee that is devoid of any conflict of interest.
Okay. You can continue, Doctor, after the clarification from the department.
Okay. Thank you very much.
Chairperson, we need to vote. We need to vote on this clause first before we go to
Oh,
the
the
next.
clause. Oh, the voting. Okay. Yeah, I give to you to call all the provinces, Aska.
Okay, thank you, Chair. As mentioned, the delegate just needs to say support, not support, or abstain. Eastern Cape.
Eastern Cape support.
Free State.
Support.
Gauteng. Gauteng.
Mama Ngwenya is in the meeting. I think she's struggling with the network because I spoke to her.
Okay, I'll continue. KZN.
KZN support.
Mama Ngwenya?
Chairperson, more killing thing in network high handle. But I managed to log. Yes, I'm supporting.
Okay.
KZN.
KZN support.
Limpopo.
Do we have a special delegate from Limpopo? Because we don't have permanent members from Limpopo. Can you pass?
Mpumalanga. Northern Cape. Northern Cape.
Mamkosa.
Northwest.
Northwest support.
Western Cape.
Western Cape support.
Chairperson, we've got 1, 2, 3, 4, 5, 6 provinces supporting that amendment of Gauteng. So that means that amendment
of Eastern Cape.
Yes. So we have 6 provinces supporting that amendment, which means that that amendment will now be accepted and it will be included in the new bill by the committee. Next clause.
Dr. Besson.
Thank you, Honorable Chair. Clause 3 of the bill, amendment of Section 3 of Act 119 of 1990, as amended by Section 2 of Act 63 of 1998. That Clause 3 be amended as follows. 1B, any fee determined in terms of subsection 1A, B, 2 shall be calculated on a cost recovery basis and shall only come into effect if the executive officer, after taking into account the available resources and the consideration of all the relevant circumstances, exempt an emerging farmer or producer from paying the full or part of thereof of the assignee fees. Such assignee fees or portion thereof shall be paid by the department. General comments. The report of the portfolio committee attached here to highlights other issues raised by the stakeholders relating to the bill before the portfolio committee and are matters that ought to be given serious consideration by the Department of Agriculture, Land Reform and Rural Development. Thank you, Honorable Chair.
Thank you. It's now you, Oscar.
Chairperson, clause 3 can be discussed with the department and the legal advisors before members can take a vote on it.
Okay. Do you want to say something, honorable members? Any comment from yourself? We don't have. I don't see any hand. Let's go to legal advisors. Oscar, I'm getting worried. It's look like there are no legal advisors in this meeting.
Everybody was sent the invitation. Everybody confirmed. The department's legal advisor should be on the platform.
Okay.
I know that the state law advisor and the parliamentary legal advisor had a bit of a clash with meetings, but they should.
Okay. But in the meantime, send them the reminders.
Well do, Chair.
Can we continue with the meeting? The department?
I'm available, Chair. Sorry, Chair. I'm the state law advisor. Yes.
Oh, thank you, Mama. Sorry, Ma. Sorry. Do we have any comment, Mama?
No. Not on the legal question. I don't have a question on this particular one.
Okay, Mom.
Yeah, but I'm a bit concerned about what the procedure in actual fact with regard to the clause 2. I see that the members have supported. I'm not sure whether they are supporting the crafting of the amendment by the Eastern Cape negotiating mandate, or they are just supporting the bill, clause 1, as it was amended in the bill that was referred to the committee. Because I also agree with what the department official was saying, raising with regard to clause 2. So now I hear that at the end, in the summation of it, the chair was saying the clause was supported with the amendments, meaning with I don't know whether with the manner in which the Eastern Cape has crafted that provision. If I can get clarity, Chair, on that one.
Oscar, can you assist?
Chairperson, like I explained, we read each amendment and the members vote on whether to accept it or reject it. So when we say support, that means we are accepting the amendment, and when we say not support, we are rejecting the amendment, and abstain is abstain. So in this case, what the legal advisor is saying, the department was saying that the bill, that the amendment was contrary to what the minister envisaged, but the members went ahead and agreed with the Eastern Cape, and therefore is amending the bill to include that amendment. So that is the clarity she's seeking. What I am saying is that thus far, the amendment was accepted and the bill will be amended, but we can always go back and re-vote, but that's maybe the members misunderstood, and we can always go back, but that is a decision that the committee has to take. Thank you.
Yeah, but I think from now, if there
Chairperson.
is an amendment, we will say we are supporting with the amendment, because we have to accept if we are accepting the bill, but we are not accepting the amendment. If that is the case, when we go to the next one, we must explain to say no, accepting with amendment, or accepting without amendment. There was somebody was trying to help.
Honorable Chair.
Yes, Honorable Kathy.
Honorable Chair, I think we should not, we should try not to confuse ourselves. Oscar explained it very well, that a clause, if an amendment is proposed by a province, then we have the opportunity to interact with the department and the legal person to understand the impact of that proposal. Then the rest of the provinces vote according to the mandate, that clause or not. This is part of the whole bill. So if they refer to the original bill, then it's a section, but there's no section mentioned in number 2. So we're working with clauses that is all proposed amendments. So let us just focus on the proposed amendments. And if there is a proposal that proposed to amend the original bill, then the legal advisor will have to tell us whether we can do that or not. But then actually they should refer to a section, because a section is of the original bill and a clause is something that we are now busy amending. So I don't think we should go with, say, we support the bill and we support the amendment. Let us just focus on the amendments, because we are busy with the whole bill and the amendments is within the bill. Thank you.
Continue.
Chairperson, could I get clarity? Would you want to leave the first clause as is, or would you like to redo the voting on that clause as per the clarity seeking from the legal advisor?
Can we start redoing it?
Okay. My hand is up. Ms. Mahlaila from the department.
Yes, ma'am.
Thank you, Chair. I'm from the Legislation Development Unit. My question is also, I guess, on the procedure. I've also noted that the KZN negotiating mandate also is proposing amendments to the very same clause too. So if voting is happening already while other provinces are yet to propose their own amendments, is it not going to be a wasting of time? Because we vote, it's accepted, and then by the time we get to the last province, and what if all the other provinces also are proposing amendments to the very clause? So I'm just asking a question, and also to ask that the committee really does consider what the department is putting forward as an objection to the proposal by the Eastern Cape on the amendment of clause 2. Mr. Makafula explained why in the drafting of the bill, it was crafted specifically to exclude the requirement to consult with stakeholders, but the requirement for objectivity is still provided for in other parts of the bill. So I just wanted to bring that to the attention of the committee, but mainly focusing on the fact that other provinces are also making recommendations to clause 2. So if you vote it now, are we closing them out, or is there going to be voting again at the end of all the provinces reading their negotiating mandates. Thank you, Chair.
Thank you very much. Does someone wanted to say something?
This Honorable Abiskaki.
Honorable Mama.
I'm not sure if you can see my hand. Chairperson, sorry, can I speak?
No, I was calling your name, ma'am. Honorable Betty, I was calling your name to give you the platform, ma'am.
Okay, thank you, Chair. Chairperson, the way I understand it, we started with clause 2, and if you, as the chair decides we redo it, it's fine with me. But my understanding of while we are going clause by clause is when you ask for discussion, then all the provinces who have a mandate from their province, like the person mentioned, that KZN also proposed an amendment. I think then each province must say, this is what my province amended or proposed, and therefore then the department should give us, and the legal advisor should give us and say, these amendments are more or less the same things, it's just in different words, or they are totally opposite of each other. And that would be the implication. And only after we understand the implication of each of these amendments, we can vote on the amendments. Otherwise, we're going to sit and go through this 9 times through the same amendments, and which one is going to replace the other one as rightfully asked. That is how I understand, because this is what the negotiating mandate is. We negotiate the different proposals. In that negotiating mandate, maybe some provinces use certain things, but legally it will have the same impact. If your province said to you, you have to ask for more clarity, like the Western Cape, and say, at least the qualifications and things, and so there's no interest of conflict, and it sounds to me that the things that's proposed is like that, then I can vote for it. If my province is silent on that, it means I can listen to all these things and I can understand, but I abstain. And if my province presented and proposed an amendment, we have to sort those amendments out at the same time so that we know whether they are in line or opposite, so that we know how we can vote. This is my understanding, and I would like some clarity on it. If I'm wrong, I will listen, but this is, I think, how most of us understands it.
Chairperson.
Honorable Kiva.
No, thank you, Chairperson. I think that we must have a full appreciation of these amendments and to the clause of the bill, and people must understand where the process begins and how it comes all the way to end up where we are today. Now, you will never find if there is nothing that is really being raised that is diametrically opposed to the contents of what is before us. Clarity-seeking questions can be dealt with right here and right now. But if the majority of the provinces are saying we are voting in favor, and they still ask a question and say that, however, maybe I need clarity here and there, it doesn't mean that we must take the process back. This is a very long drawn process. And therefore, for us to say on the basis of minor matters that we may want to say that it must go back all the way, it can actually have to go back, from the primary setting, because it would mean that this committee, which is the line function committee, has rejected it, and therefore by implication, it can't serve on the plenary. and then it gets taken back. And the process of legislation development in our country has become very tedious and very slow, purely because people, they don't understand that bills and acts and laws and pieces of legislation are living documents. You will never get to a point wherein you say everything is 200%. For the intents and purpose of why this has served in the National Assembly and now is serving here, so that it can go to our own. The content and everything has followed through the eye of a needle. Let us not really belabor on these issues. They will not really have a material change in terms of the complexion of what has been achieved thus far. For me, I would say let's take it to a vote. Thank you very much.
No, thank you very much, Honorable Kiva. I think after the explanation and clarity, I'll say let's continue, not going back, because we'll be wasting time just to go back. Honorable members, and let me plead with you, department, again to say the reason why you brought us this bill is to go to our province to get a mandate. And after getting the mandate from the provinces, our provinces went to, for example, like Honorable Kiwa was saying, it can, not everything can be 100%. But there and there, the provinces has the right to raise any issues that they want to raise. So let's allow the provinces to read their mandate. That's why we are saying it is a negotiating mandate. And from there, honorable members, they will negotiate for that mandate. Not, and then we'll get other clarity from the legal. For now, you department, you have to answer to say this and this and this. It was supposed to be like this and this, but not to get to say the procedure, do this and do this. Please. Can we continue, because this clause were in the clause, another clause to get vote for the this clause, Aska?
Chairperson, Chairperson, it's Nzube here.
Yes, Honorable Nzube.
Yes, Chairperson. My apology for coming late. But I don't think you have clarified or given a clarity on the modus of operandi, Chair, that as there are negotiating mandates, and then I think after negotiating mandates are being read, the province, we will vote on the negotiating mandates. I want to check, Chairperson. That's why I'm asking about the modus operandi, that in relation to, I think one member spoke about it. What then happens that we have voted for in favor of certain amendments on the Eastern Cape one, and then you find it that in Free State, it happens to have a different overview in terms of everything. Wouldn't that cause a confusion? That's why I wanted to check in terms of the modus operandi, Chairperson. What are we really doing?
I don't think, like I said, each and every province has the right to raise the mandate from their province. I don't think it's going to cause a confusion, Honorable Mzube. The mandate from your province, you'll read the mandate from your province as it is, and then you will negotiate with others, with other provinces. If the provinces don't accept your mandate, it will be not accepted. But if honorable members are accepting your mandate, it will be accepted also. So there's no confusion, Honorable Itumele.
Yes, Chairperson, but the question is, why are we effecting the votes before we check all the mandates?
No, it has to be like that. That's the procedure. That's the procedure, Honorable Nzube. And it's not for the first time we are dealing with the negotiating mandate. Every time when we deal with the negotiating mandate, we are doing the same as we are doing today. We cannot check all the mandates from the provinces. No. We go province by province by province until the last province, Honorable Nzube. Can you continue, Honorable, Asker?
Thank you, Chair. Chair, I just wanted to check if the close on the screen, if all the discussions are finished and whether we can go ahead with the voting.
Yes, it's time for voting now.
Chairperson, then I call for Eastern Cape.
Eastern Cape supports.
Free State.
Abstain.
Gauteng.
Gauteng support. Gauteng support, Chair.
KZN.
KZN support, sir.
Limpopo.
Pass.
Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Northwest support.
Western Cape.
Western Cape abstain.
1, 2, 3, 4. Chairperson, we have 4 provinces supporting, so the amendment is not agreed to. We can go to the next mandate, Chairperson. The next mandate, Chairperson, is the Free State Province.
Chairperson, if I may, sorry. Chairperson, sorry.
Yes, Honorable Dr. Bese. Who's
No, it's an official. Yeah, it's Pilima Kafla from the Department of Agriculture. I think we have not been given a response. We have not been given an opportunity to reflect on the clause as we did on the first one.
Oh, okay.
Can I go ahead?
I don't think because we have already voted that.
Okay.
Okay.
Thanks.
Next time. Sorry for that. Can you, Honorable Nzube, do you want the secretary to read your mandate or you will read the mandate?
The secretary will read it, Chairperson.
Okay. Kubas, can you read the mandate?
The mandate from the Free State Legislature is as follows. The name of the bill, Agricultural Product Standards Amendment Bill B15B of 2021. The bill was deliberated on the 26th of September 2023, and the vote of the legislature is the Portfolio Committee on Agriculture, Rural Economic Development, Small Business, Sports, Arts and Culture, as designated by the Free State Legislature, votes in favor of the bill. And I do not see any amendments, Chair.
Okay. Thank you. Any Anyone who want to, any comment?
We can move to Gauteng, Chair.
So we are not voting on this one.
No, Chair, there's no amendments. The province
Okay.
supports with no amendments.
Okay, no, thanks. Gauteng? Honorable Ngwenya, because we don't have, your network is not clear, I'll request the official secretariat to read your mandate on your behalf. To allow
Thanks
me.
very much, Chair. I would like the secretary to read Gauteng mandate, please. Thank you.
Thank you, Ma.
The Gauteng negotiating mandate for agricultural product standards and amendment bill B15B of 2021. The deliberation on the bill took place on the 22nd of September 2023, and the vote of the legislature is as follows. The Gauteng Province Legislature votes in favor of the Agricultural Product Standards Amendment Bill, subject to the following amendments being considered. The following proposed amendments, I will start with Clause 2. In Clause 2, on line 17, after the word systems, insert the word and. And then the second proposal on line 18, delete the words with no direct or indirect personal or financial interest and insert the words with no direct or indirect personal or financial interest. The current proposed wording does not make it clear that the requirement that an assignee must not have a direct or indirect personal or financial interest in any of the instances named under 1 and 2. It is proposed that this clause be amended in the following manner. A. The Minister may, for the purposes of the application of this Act or certain provisions thereof, then delete with regard to a particular product, designate any person, undertaking, body, institution, association, or board having particular knowledge in respect of the product concerned as an assignee in respect to that product, and replace with designate as assignee a person, undertaking, body, institution, association, or board, I, having a particular knowledge of the product concerned, or 2, having a particular knowledge of the relevant management control systems, deleting with no direct or indirect personal or financial interest, and 3, insert with no direct or indirect personal or financial interest. That is proposed clause 2 from Gauteng.
Thank you, Kobas. Honorable members, do we have any comment on the mandate from Gauteng?
Chair, may I ask?
Yes, ma'am.
This clause 2, we've already voted on this clause 2 when we started on the Eastern Cape. Now, can the department and the legal people tell us what is the change, what is the difference between
No, before I wanted you members to negotiate, to say something, and then I'll go to the legal and department.
Okay, I ask this question because what is in front of me from the Western Cape, it is submitted that it be more clearly put that assignees possess the necessary qualifications of product or in the industry knowledge in order to fulfill the task, as well as being free of any conflict of interest. So this gives me a broad base on, I need to understand what the implication of this is and the differences between the two amendments. to make up my mind how I'm going to vote. Thank you.
Okay, ma'am. Legal advisor from State Attorney.
Thank you, Chair. The crafting of this proposed amendment is problematic in the sense that I don't know whether they've noticed that with regard to Roman 1 and 2, it's either you choose one or you choose two, but all those will be with no direct or direct personal or financial interest. So now, when they craft it as they are proposing now, to make it a standalone, it will be a problem, which means now it will not even make sense, because now you will read it as the minister may designate assigning a person, undertaking, body, institution, association, or board with no direct personal or financial interest. Whereas initially it was proposed that it will be one, Roman 1, that is the minister may designate as assigning a person undertaking body, institution, association, or board having a particular knowledge of the product concerned, with no direct or indirect personal or financial interest. So that is the purpose of that provision and its interpretation. So now it will not be interpreted in the way it was originally crafted by this proposed amendment. Thank you, Chair.
Thank you very much, Ma.
Chair, I have a question.
Yes, Ma.
Like it's been explained, the minister may, for the purposes of the application of this act or certain provisions thereof, designate as assigning a person undertaking, body, institution, association, or board, and it means that any of those having a particular knowledge. So the designated assignee person, undertaking, body, or institution have to have a specific knowledge of the product concerned, or have to have a particular knowledge of the relevant management control systems, with no direct or indirect personal or financial interest. It means that the person that's been taken aboard should not have a direct personal or financial interest in the product, so should not be able to gain something out of it. So to me, it makes totally sense. What I would like to know is, yes, I understand that you say it's not the way the minister intends it, but what is the difference? Because as it reads here, for me as a layperson, it makes absolutely sense. So I want to know, what is it that contradicts the minister? Or what is it that, not the minister, the people who wrote the law, what is it that they say it will be wrongly interpreted? Thank you.
Thank you, Honorable Kathy. Legal advisor, can you continue with answering this question?
Thank you, Chair. As I said, the minister has an option of taking Roman 1 or 2, but that Roman 1 also goes with no direct or indirect personal or financial interest. And if takes 2, Roman 2, having a particular knowledge on the relevant management control system with no direct or indirect personal or financial interest. So, as they are proposing now, it says now the minister may then have 3, which is with no direct or indirect personal financial interest, meaning that now, if you chooses Roman 1, there will be no part or that refers to with no direct or indirect personal or financial interest. I hope it is clear in that. Thank you, Chair.
Thank you very much, Ma. Thank you very much for your clarity. Can we continue?
Chairperson?
Oh, Honorable Kathy.
I hear what she is saying. To me, the way I read it, it's not a choice between 1, 2, or 3. It's not a choice between Roman 1, 2, and 3. It is an addition. So if there could be a problem with interpreting it, then this province whose proposal it is will have to think of, should it be all put in one sentence? Because the way I read it, the minister may, for the purpose of the application of this act for certain providers, therefore designate a person, one of those, or board, meaning that those people, and then add on 1, 2, and 3, having a particular knowledge of the level of. So it means that whether the minister choose a person, an undertaking, a body, a institution, association, or a board, they have to have a particular knowledge of the product concerned, or they have to have a particular knowledge of the relevant management control systems, and also they should not have a direct or indirect personal or financial interest. That is how I read it.
Can the department assist?
Thank you. Thank you very much, Chairperson. I think the proposed a change by Gauteng for us, rather than bringing a clarity to what we thought we wanted to infuse in terms of making it very clear that there should not be any conflict of interest, whether a person has a particular knowledge or a particular knowledge in the relevant management control system. It actually brings another dimension. Well, the change itself is very cosmetic, so I don't know whether it would actually be, in order to deal with clarity issues in future and actually having problems with interpretation, if it would actually not be okay to leave it as we proposed it, because that actually gives you alternatives, but then emphasizes that in these 2 alternatives that you are to appoint those people either with a particular knowledge or relevant management control system, such a body or juristic or natural person should not necessarily be having a direct or indirect personal or financial interest. Whereas in the proposed change or amendment, you are bringing now 3 clauses, which then may actually suggest that you can actually appoint an SID purely on the basis of that SID not having a direct or indirect personal or financial interest. So that is not necessarily the intention that we wanted to bring to the fore, is that essentially you need to have that requisite knowledge, but most importantly, you don't have to be conflicted. So we would actually say that the initial proposal that we had should actually stay as is. But of course, we are in the hands of the legislature.
Thank you, Ndata Makafla. Honorable members, Honorable Abakafne.
Chairperson, my proposal is that we request this specific clause to be sent back to the province whose proposal it is, so that they can have the opportunity to rewrite this in the way they meant it to be. because we all understand now that they actually meant that all these things should be a sort of a criteria, and the department and the legal advisor said no. If it's written like that, it means it's an either or choice. That was the way I understand it, not the province's idea to have it an either or choice. Or we must just have to vote it out or vote on it and see what happens. But I'm talking on behalf of my province that says that they want more clarity on that the assignees possesses the necessary qualifications, product or industry knowledge in order to fulfill their task, as well as being free of any conflict of interest. And that to me gives me what this province put out is something that gives more clarity, and that is why I have this request and say let the department or the province gives us more clarity if that is possible. Thank you.
No, thank you very much, Honorable Labuskaghni. But unfortunately, ma'am, you cannot speak on behalf of other province. If Gauteng wanted to go back to their province, they will say that, not other province to send them back. So I understand your point, but unfortunately, you cannot direct them to say they must request or to say they must go back, unfortunately. You will talk on behalf of your province when your mandate comes. So let's continue, honorable members. Asker?
Chairperson, let me take this opportunity to ask, I don't want a repeat of our previous, is all the discussions on this matter concluded so that we can vote?
Sure. Did the department, oh yeah, department spoke. Okay.
So everybody's happy, we can vote. Okay. We're voting on clause 2A, on clause 2, Eastern Cape.
Eastern Cape abstain.
Free State.
Free State, you're abstaining.
Gauteng.
Gauteng, support, Chair.
KZN.
KZN abstain.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Hey. Northwest abstain.
Western Cape.
Western Cape abstain.
Chair, that we have 1, 2, 3, 4, 5, 6 abstainees. The amendment was not agreed to. Kobus, the next clause, please.
Before that, members, I know we are dealing with agriculture. In the platform, we are having Deputy Minister of Environment. Before we can go to the next mandate, is it a clause or mandate? Before we go, can I call the Deputy Minister just to greet us or to say something, and she can leave the meet?
No, Chair, no. Chair, on a point of order. Chair, you can't.
Call
On a
Deputy
serious
Minister.
note. Chairperson, I'm calling you to order. We are right in the middle of a meeting. That can't be accepted. It's not done. I propose we continue with our meeting.
Okay, you know why I'm saying that the deputy minister can say something in the meeting? It's because we call the department at 2:30, and they join the meeting at 2:30. And before that, she was putting an apology to say, I'll join at 2:30, and then from there, I'll request to leave because I'm in the meeting. And for us to be still here at 3:00, it's not her fault or the Department of Environment's fault. It is our fault, not them. So that is why I'm saying I'm calling her to come and say something, and she can leave the meeting.
Chair, you know the reason why members of the executive sometimes they undermine us in committees is precisely because of actions like these ones. We are right in the middle of a meeting. Not even begin to make such utterances that it's not her fault. When we are in a meeting, all of us, if she wants to put an apology, let her put an apology, but we're in the middle of a meeting. Let the meeting continue. And then when we get to that point, you will call her. If she's not here, she's not here.
Honorable Deputy Minister, can you say something? Deputy Minister? Oh, silly, Anolene. Okay, she's not in the meeting. You can continue, Gobas.
Proposed clause 4C. This clause seeks to amend section 3A(4) of the Principal Act by inserting the words or subsection 2C. The current section reads, for in the case of action under subsection 1B, C, D, or E, or subsection 2C, by the relevant person referred to in subsection 1, the owner of the product in question shall pay the prescribed fees or the amount determined by the assignee, as the case may be, for such action. The reference to fees determined by the assignee maintains the mischief that clause 3 seeks to remedy. Thus, it is suggested that the regulatory framework introduced by subclause 3, 1b, be equally applicable to this clause to ensure accountability and transparency in fees set by assignees. That's the clause, Chair.
Thank you. Honorable members, here is the clause from Gauteng. Can we discuss it before I give the department? Or if you have any question, can you ask a question? So that when department come and legal advisor comes in, they responded to your questions. None. Department, legal advisor?
Thank you, Chair. No, I've got nothing to say with regard to this.
Okay, thank you. Department?
Thank you very much, Chairperson. Look, I don't know the mischief that is actually being referred to, that is actually being sought to be addressed, is still applicable to the section. What we wanted to bring into this equation, specifically on that section, was that the section previously provided only for inspection and did not provide for auditing, and then auditing is actually brought in. But in determining fees, what we seek to achieve under Section 3 will still be something that applies to this very section. So it does not necessarily militate against the very same mischief that we wanted to address under Section 3A. So we think that it should stay as is, because it is actually, more than anything, is in concert with what is actually being understood to be the case, that in determining fees, consultation would have to happen with all the affected stakeholders via the executive officer, which is still going to find application even on this very section. Thank you.
Okay. Oscar?
Thank you, Chair. Once again, I would just like to check if all clarity-seeking questions and debates have concluded. Okay, I will continue with the voting. The voting on clause 4C is commencing. Eastern Cape.
Honorable Mkiva? Honorable Mkiva?
Okay, we can always come back again, Chair. I think
Free State abstain.
Okay, Free State abstains. Gauteng.
Gauteng support.
KZN.
KZN abstain.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Abstain.
Western Cape.
Abstain.
Coming back to Eastern Cape. Chairperson, we have 1, 2, 3, 4, 5. 5 abstains. The amendment was not agreed to, Chairperson. We now moving to KZN, Chair.
Honorable Bibi, I just want to check with you. Do you read your mandate, or you'll ask the Secretariat to read it?
Thank you, Chair. Can I ask the Secretariat to read it for me? Thank you.
Thank you, Mama.
Mama.
Kobus?
The KZN negotiating mandate for agricultural products standards amendment bill, number of bill B15B 2021, date of deliberation 3 August 2023. The vote of the legislature is as follows. The Portfolio Committee on Agriculture met today, Thursday, the 3rd of August 2023, and agreed to mandate the KwaZulu-Natal delegation to support the Agricultural Products Standards Amendment Bill B15B of 2021 with the following comment for consideration. Clause 4, amending Section 3A. The question was asked whether the cost for auditors will be claimed or recovered from the small-scale farmers prior to or post the production of agricultural products. It is proposed that the department should consider looking at this when they draft the regulations to accommodate small-scale farmers who are struggling financially or lacking the necessary skills. That one comment for consideration, Chair.
Chairperson, if I may.
Yes, Oscar.
Chairperson, this mandate did not have an amendment, but it did have a comment for consideration, which means that the department will have to respond to the province in writing on this comment for consideration. Thank you, Chair.
Thank you very much, Aska. Now it means we are because we are going to another province.
Limpopo.
Limpopo. I'll request the Secretariat to read the mandate from Limpopo because somebody from Limpopo, she's not in the meeting.
For the Agricultural Products Standards Amendment Bill B15B 2021, date of deliberation 26 September 2023. The vote of the legislature is as follows. Provincial NCOP permanent delegates to negotiate in favor of the bill. No proposed amendments, Chair.
Thank you. Next province.
Mpumalanga.
I'll request the Secretariat to deal with to read the mandate from Mpumalanga because Honorable Nyambi is not in the meeting.
The negotiating mandate for the Agricultural Products Standards Amendment Bill B15B of 2021 as deliberated on the 13th September 2023. The vote of the legislature is as follows. The Portfolio Committee on Agriculture, Rural Development, Land and Environmental Affairs, after considering the Agricultural Product Standards Amendment Bill B15B of 2021, confers on a permanent delegate representing Mpumalanga Province and the NCOP a mandate to negotiate in favour of the bill. There's no amendments, Chair.
Yes,
Northern Cape.
Northern Cape.
I request the Secretary to read the negotiating mandate.
The Northern Cape's mandate on the Agricultural Products Standards Amendment Bill B15B of 2021, deliberated on Friday the 15th of September 2023, is as follows. The legislature votes in favour of the bill and no amendments, Chair.
Next province, which is
Northwest.
my province. I'll request Gobas to read the mandate.
Oscar, I'm sorry, on my list, I don't have an Northwest negotiating mandate. Can you possibly share on your side?
My apologies, I just received it. I will send it to you, Kobus. The chairperson, they will send it to me on a WhatsApp. I can read the mandate.
Can you do that?
Let's open it up, chairperson. The North, to the chairperson of the Select Committee on Land Reform, Environment, Mineral Resources and Energy, Agriculture Product Standards Amendment Bill, the Northwest Provincial Legislature abstains from voting on the Agricultural Product Standards Amendment Bill. Chairperson, I take it you do have a copy because you sent it to me, so you would confirm that what I have read is the correct mandate, Chairperson.
You are saying?
The Northwest Provincial Legislature abstains from voting on the Agricultural Product Standards Amendment Bill, Chair. They abstain from voting.
Okay. Yeah, this is the mandate. Yeah, it's their mandate.
The next province is the Western Cape, Chair. It's the final province.
Thank you,
Okay.
Chair. Secretary
So,
can read.
before we oh, okay, okay. Western Cape.
The Western Cape Standing Committee on Agriculture, Environmental Affairs and Development Planning, having considered the subject of the Agriculture Products Standards Amendment Bill B15B of 2021 in the NCOP, referred to it in accordance with Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to support the bill. The committee further proposes consideration of the following. Clause 1, definition audit. It is submitted that affected industries gain the right to ensure that the costs associated with the auditing process are within limits acceptable to the relevant industry. The mere drafting and submission of a budget will not put the relevant industry in a strong enough position to ensure that unnecessary costs, which will have to be recovered from consumers, are not incurred. Oscar, I just want to make sure if these are considerations or proposed changes, if I should continue or pause at the first.
That would be the first amendment. We will discuss it and then vote on it.
Okay. Can we give to the members to discuss it? And then before, after that, legal advisor and the department. Honorable members, do you have any comment on this clause? Let me give the legal advisor. Legal advisor? Okay, department? Oh, ma'am, legal advisor?
Chair, I don't know what to comment because there's no proposed amendment.
Okay.
I don't know how to deal. Probably the department will be able to
say something.
Yes.
Okay. Department, we need your comment on this one, on this clause.
Thank you, Chairperson. I think aside from the fact that there's nothing that has been said about cost under definition for auditing, I can just say that under Section 3 of the amendment bill, it actually addresses the very same concern that have been raised by Western Cape, in that the relevant affected stakeholders will certainly be consulted to ensure that the costs indeed are costs that are to be affordable by the very same industry, and they are to be for auditing purposes and for cost recovery that are going to be recovered on cost recovery basis. So it has been addressed in Section 3A, but I have to maintain that it's not necessarily provided for under the set clause that has been mentioned.
Okay. Can you continue?
Okay. Eastern Cape.
Honorable Kiva, because Honorable Kiva is in the meeting. I don't know why he's not commenting.
Okay.
Cape abstain.
Eastern Cape abstains. Free State.
Oh, who was talking?
Yeah, there is a lead member from the Eastern Cape. It's a call the province and not call my name, Honorable Chairperson. Thank you.
Delegate from Eastern Cape. Honorable Nsube, can you mute, please? Eastern Cape?
Eastern Cape abstain.
Oh, Dr. Bese.
Yes.
Free State.
Honorable Nsube?
Free State, Free State abstain, Chairperson.
Gauteng.
Gauteng, Mamwini.
Thanks, Chair. Gauteng support.
I have the support.
KZN.
KZN abstain.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Okay.
Northwest.
Northwest abstain.
Western Cape.
Western Cape support.
Chairperson, we have 3, 4, 5 abstains. So the amendment was not agreed to, Chairperson. Robert.
Clause 2. It is submitted that it be more clearly put that assignees possess the necessary qualifications, product or industry knowledge in order to fulfill their tasks, as well as being free of any conflict of interest. So
Okay.
that's the end of the proposal.
Okay. Any comment? Department?
Thank you, Chairperson. I think the sections or the proposed sections in the bill makes it very clear. The mere fact that we actually certain about particular knowledge of the relevant product and particular relevant knowledge of management control system, it actually talks to a compact of skills, competencies, and indeed qualification that should actually qualify that particular knowledge. So it is actually expressly and tacitly implied in that very section that we propose that the kind of people, the kind of juristic or natural persons that you are to designate should have the requisite knowledge, the requisite skills, and indeed the requisite qualifications to undertake the work for which they will be assigned. And indeed, the conflict of interest is what we would actually try to avoid, in that they should not have any direct or indirect personal or financial interest. So it has already been provided for.
Okay. Oscar?
Thank you, Chair. Delegate from Eastern Cape.
Dr. Besser?
Eastern Cape abstain.
Free State.
Abstain.
Gauteng.
Gauteng abstain. Gauteng abstain, Chair.
KZN.
KZN abstain.
KZN.
KZN abstain.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Northwest abstain.
Western Cape.
Support.
Chairperson, we have 3 abstains on this amendment. The amendment was not agreed to. Kobus, next.
Clause 4, Section 3A of the Principal Act. It is submitted that on page 3, line 50, the word formation be replaced with the word information.
Yes, honorable members, comment on this one? No, none. Let me give to the state attorney, legal advisor, and department. Department.
Thank you, Chair. State Law Advisor.
Oh, yes.
Yes. That is, it is noted, Chair.
Thank you. Department.
Well, Chairperson, indeed, on this one, we have to concur with what has been proposed. Thank you.
Thank you. Back to you, Aska.
Thank you, Chair. We'll call it a Eastern Cape delegate.
Eastern Cape supports.
Free State.
Abstain.
Gauteng.
Thanks, Chair. Gauteng abstain.
KZN.
KZN abstain.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Northwest abstain.
Western Cape.
Support.
Chairperson, we have majority abstains. Okay. Amendment was not agreed to. The last amendment.
Memorandum on the objects of the amendment bill. It is submitted that on page 5, point number 1.2, second sentence, that the word audition be replaced with the word auditing. That's the proposal.
Yes. Members, any comment? Clarity seeking question? State advisor? State law? Legal advisors? None. Department?
Well, I think the proposal as contained there for a replacement of the word audition with auditing is accepted.
Thank you. Aska?
Chairperson, we'll go to the vote. Eastern Cape. Eastern Cape delegate.
Eastern Cape supports.
Free State.
Abstain.
Gauteng.
Thanks, Chair. Gauteng abstain.
KZN.
KZN abstain.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Northwest support.
Chairperson, we have a majority of abstains, so the amendment is not agreed to.
Did you call Eastern Cape, Western Cape?
Yes, sir. My apologies. Western Cape.
Support.
Sorry. So we've got a majority of abstains, man. My apologies. That is the end. That is the end of the mandates for the Agricultural Products Standards Amendment Bill. The only amendment agreed to was the Eastern Cape First Amendment.
Chairperson, just before Chairperson.
Yes, ma'am.
Chairperson, is Ntube here?
Eh?
Chairperson?
Honorable Ntube?
Yes, Chairperson. I think you initially you had alluded that I think from I would speak for myself. There was really misunderstanding on the Eastern Cape amendments, the first one that we had to deal with, Chairperson. So initially you had said that we are going to check it first because I do recall that there was a very misunderstanding in terms of the entire bill or the amendments. So for the record, Chairperson, I wish to state, if you would allow, that even on the first Eastern Cape amendment, Free State does abstain.
Okay. Let me check other provinces because really it was a confusion there and misunderstanding to all of us. That's
Chairperson,
why I was saying let's start. Can we go to check with the province, Aska?
Chair, I would say let's go. If that is your wish, I would say we would do a revote on that amendment, Chair.
Yeah, do that before we
close.
Finish.
Yeah. Okay, Chairperson. Eastern Cape.
Eastern Cape supports.
Free State.
Free State abstain.
I will record it that Free State had changed their vote from support to abstain. Gauteng.
Thanks, Chair. Gauteng abstain.
Chair, I will record Gauteng has changed their vote from support to abstain. KZN.
KZN supports.
Limpopo. Not on the platform. Mpumalanga. Not on the platform. Northern Cape.
Northern Cape abstain.
Chairperson, we will change. Northern Cape was not on the platform early on. It's now abstain. Northwest.
Northwest abstain.
Let the record show Northwest changed their vote from support to abstain. Western Cape.
Abstain. Chair, I don't know what we are voting on now.
Kobus, can you please just bring up Eastern
on the bill
Cape
itself?
The First Amendment on Eastern Cape's mandate.
The First Amendment on Eastern Cape's mandate.
Do you wish me to read the clause again, or
No
just have
problem,
it
no
on the
problem.
screen?
I abstain. I abstain.
The record will reflect Western Cape changed their vote from support to abstain. Chairperson, we have 1, 2, 3, 4, 5 abstains on this amendment, which means this amendment has not been agreed to, which also means that none of the amendments on the Agricultural Product Standards Amendment Bill coming from the provinces have been agreed to, which means that the bill stays as is, as was referred by the Portfolio Committee Chairperson. That would be it for the mandates and all the amendments before the committee on this bill, Chairperson. Thank you.
Thank you very much, Aska. Let me take this opportunity to thank the department. We are done with the department, which is Department of Agriculture, Rural Development and Land Affairs. We are done. Thank you very much to come on a platform to clarify, honorable members, and to answer all the questions that are coming from the provinces. Thank you very much. Now the Department of Agriculture, you are released. We will remain with the Department of Environment, Fishery, Forestry. Didi Jindo, or are you in the meeting? Didi Jindo.
Good afternoon, Chairperson. Good afternoon, Chairperson, and good afternoon, members. Ooh.
Yes, ma'am.
Oh, not just I heard I was having a bit of a. I don't know if it's my system. Chair, am I audible?
Yes, ma'am, I can hear you.
Oh, okay. Apologies about that.
Hello, ma'am.
Yes, Chairperson.
Okay. I was told when the DM left the meeting, she said you lead the delegation. Honorable members, now we are dealing with the new mandate, which is the mandate from the mandate of Veld bill. So can we start with the mandate? I already welcomed the department when I opened the meeting. I think those who were not in the meeting, you are welcome from the Department of Environment. You are welcome. Can we continue, Askam?
Thank you, Chairperson. The mandates received from the provinces. We can start off with the Free State Province, Chairperson.
Oh, we didn't receive any mandate from Eastern Cape?
No, Chair.
Eastern...
No,
okay.
Chair.
Okay. So start with Free State. Free State, do you want to read your mandate, or you allow Secretariat to read it?
The Secretariat, please, Chairperson.
Thank you very much, Honorable Ntube.
The Free State negotiating mandate on the National Veld and Forest Fire Amendment Bill, B24B of 2021, reads as follows. Date of deliberation, 1 September 2023. Vote of the Legislature, the Portfolio Committee on Agriculture, Rural Economic Development, Small Business, Sports, Arts and Culture, as designated by the Free State Legislature, votes in favour of the bill. And no amendments.
Thank you. If there is no amendment, let's go to another province.
Gauteng is next, Chair.
Honorable Ngwenya, I ask, but because you don't have the network, a good network, I'll request the Secretariat to read your mandate.
Thanks, Chair. Thanks, Chair.
The negotiating mandates from Gauteng Province, the National Veld and Forest Fires Amendment Bill, B24B of 2021, deliberated on the 7th of September 2023. The vote of the legislature is as follows. The Gauteng Provincial Legislature votes in favour of the National Veld and Forest Fires Amendment Bill, B24B of 2021, subject to the following amendments being considered. The proposed amendments, Clause 7, amending Section 26(2) and 3 of the Principal Act. This clause proposes to extend enforcement powers of this Act to traditional leaders, provided that they have been trained to be competent by an accredited institution to exercise powers to enter, search, arrest, and seize in terms of this Act. It is recommended that it be clearly indicated that the training of the traditional leaders must be accompanied with necessary accreditation. The powers that could potentially be bestowed upon traditional leaders are quite extensive and require proper training and accreditation. Thus, clause could be amended as follows. In line 8, after the words trained, insert the words and accredited. 2A, a forest officer, a police officer, a peace officer, a traditional leader, as defined in Section 1 of the Traditional and Khoisan Leadership Act, and an officer appointed in terms of Section 5 or 6 of the Fire Brigade Services Act of 1987, Act 99 of 1987, have the power to enforce the Act in terms of this chapter, provided that they have been trained and accredited to be competent by an accredited institution to exercise powers to enter, search, arrest, and seize in terms of the Act. That is the end of that proposal, Chair.
Honorable members, any comment? None. Let me give to State Attorney, State Advisor, Legal Advisor.
Good afternoon, Chair. Can the members hear me?
Ms. Claude Buom.
Yes, Chairperson, I'm not sure if the members can hear me. Am I audible?
Can you raise your voice?
Can the members hear me now?
Yes.
Thank you, Chairperson. Good afternoon to everyone in the meeting. Chair, I just want to, before I answer the question, if it's possible, I already asked the secretary if I can, if the meeting goes longer than 4:30, if I can be excused. I'm not sure whether Advocate Jenkins will join by that time. He's the parliamentary advisor. And then the lawyer from the department, Mr. Mkubesi, is also in the meeting to further assist the committee. That is in order, Chair.
Okay. Okay. Okay.
Thank you, Chair. Chair, with regards to this amendment, our view is that the section already said accredited institution. So any training from that institution would be accredited. So adding this word and accredited wouldn't make any difference to the section because it would be from an accredited institution, Chair. Thank you.
Thank you, ma'am. DM, you are in the meeting. The time when I was calling you, because of the network, you were out. I don't know whether you would like to say something before I give.
Thank you very much, Chairperson, and good afternoon to yourself and honorable members. Yes, indeed, I am on the road. I am losing my network now and then. Yeah, no, I don't have issues, Chairperson. I have been taken through by the DTG and the team with regard to this presentation that they're making to the select committee. But firstly, let me convey my condolences to Honorable Mkiva and the family for the loss of his brother. One can just say that may his soul rest in peace. From myself, Chairperson, I think everything is still in order. I'm just following the presentation, although I have been taken through the presentation. Thank you very much, Chairperson.
Thank you very much, Honorable DM. Because you have already raised the issue that you are on the road, your network is bad. But for for being in the meeting, we really appreciated your presence to be in the meeting. It shows that this department is taking the committee serious. Anyone from the department, can you say something? DM has alluded her own version.
Thank you, Chair, and thank you, members. I keep getting feedback. I don't know if it's my connection, but if I do lose it, I will also request my colleagues from legal to assist in case I'm not audible. So I will get advice from you, Chair. In terms of this proposal, I would like to support what has been raised by, I keep getting feedback, that has been raised by the state law advisor, in the sense that we are already talking about a training in terms of an accredited institution. So according to our proposal, that there's probably no need to repeat that word of accredited in that sentence because it's already covered. And also, I think already clause 7 deals with the matter with regards to where we have 26(2)(a), where we are talking about a train that provided the people are trained in to be competent and by an accredited institution. Thank you, Chair.
Thank
I
you
hope
very
I
much.
was audible because I keep getting feedback on my side, so I don't know.
No, you were. But
Okay.
if your legal advisor wanted to say something, he or she is also welcomed.
Okay, Mr. Kobese, you can come in.
Okay, no, thank you, ma'am. Good afternoon, Chair, honorable members, and DM and colleagues. No, from our side, I think the colleagues have covered us, the DDG and the state law advisor. Just safe to state that accreditation relates to institutions who are offering the training that must be accredited, not people who are receiving training. So that insertion, in our view, is misplaced. Thank you, Chair.
Thank you. Aska?
Thank you, Chair. I'd just like to check if all questions and comment sessions is all finished. Okay, Chair. We'll go to the voting. Eastern Cape delegate. Okay, not on the platform.
I tell her not to be.
Eastern Cape. Either Dr. Mbese or Mr. Mkiva. Okay. Free State.
Free State abstain.
Gauteng.
Thanks, Chair. Gauteng abstain.
KZN.
KZN abstain.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Northwest abstain.
Western Cape.
Western Cape abstain.
Wobus.
Clause 8, introducing a new section 32A in the Principal Act. it is proposed that clause 32A2 be amended by inserting the words "in writing" in line 22 after the word "noted." Thus, it would read as follows. 2. An appeal under subsection 1 must be noted in writing and shall be dealt with in the manner and in accordance with the procedure prescribed by the Minister in the regulations. Furthermore, the right to representation when an aggrieved party is noting an appeal must not be overlooked. Thus, it is proposed that there be a subclause 4 that provides as follows. 4. A person who appeals in terms of subsection 1 has the right to representation. Lastly, in the interest of ensuring independence and impartiality of the appeals process as required by Section 34 of the Constitution, perhaps it would be prudent to consider having an appeals board or forum that would be constituted by suitably qualified and independent personnel to investigate and consider appeals. A clause dealing with such could read as follows. 32B, Appeal Board, Composition and Membership. 1. The Minister may constitute a board known as the Appeal Board to investigate and consider any appeal referred to in terms of Section 32A1. Number 2, the board must consist of at least 3 members appointed by the Minister, of whom A, 1 person must be appointed on account of his or her knowledge in the relevant fields of the law, and B, 2 or more persons must have expert knowledge of the subject of the appeal. 3. The Minister must designate the person referred to in subsection 2A as the chairperson. Number 4. The remuneration of a member of the board must be prescribed after consultation with the Minister of Finance. 5. Any person appointed in terms of subsection 2 must recuse himself or herself as a member of the board if he or she has any direct or indirect personal interest in the outcome of the appeal. This proposed clause may also address any potential capacity issues in the appeals process in the Ministry. That is the end of this proposed amendment, Chair.
Chairperson, what we need to discuss and vote on would be the first one, clause 7. Kobus read all of them. We were supposed to go through one by one, but it's not a train smash. Kobus, go up again. Up. Yes, up.
Sorry, was clause 7 not dealt with, Oscar?
No, we never dealt with any of them. Okay, Chair, we need to discuss and vote on clause 7.
Okay. Can I give the members to comment and then from
My
there I'll give...
apologies, Chair, my apologies. Sorry, I'm getting confused. The next one, sorry, it is clause 8. Clause 8, sorry, Kobus. 2, clause 8.2. That is the one we must discuss.
Clause 8.2.
8.2, yes.
Yes. Honorable members, can
Sorry,
we
Kobus.
discuss clause 8.2? If you have a question on that, can you raise it? If you have any comment, can you raise it? Then I can give to the legal advisor and the department to respond. I don't see any hand. So let me give to the DM.
Thank you very much, Chairperson. Chairperson, I am following the presentation. I don't have any issues. Where I have issues, I will always raise my hand. Thank you very much, Chairperson.
Okay, department.
Mr. Okoboso, do you want to come in?
No, thanks to the Chief. from our side, we support the proposed insertion of the wording in writing. It complements that provision. Thank you, Chair.
Ms. Grootboom.
Thank you, Chairperson. Chair, if I don't in principle disagree with the proposal, just for purposes of looking at the provision as it currently reads. It says in the manner and in accordance with the procedure as prescribed. So the minister would of course prescribe the procedure and the manner what is suggested here is for it to be in writing. So I'm neither here nor there, Chairperson, but I'm erring more on the side that the in writing be contained in the regulations that the minister would prescribe, because the minister may say there must be a form, there must be X, Y, after Z. So I think the best procedure in this instance would be to let it be indicated in the regulations that will be prescribed by the minister, Chairperson. Yeah, that is my view, Chair. Thank you.
Thank you very much, ma'am. Pascal?
Thank you, Chairperson. I will call again the provinces to vote on the clause 8, subsection 2. Eastern Cape. Free State.
Abstained.
Gauteng. Gauteng.
Thanks, Chair. Gauteng support.
KZN.
KZN support.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Northwest support.
Western Cape.
Abstain.
Apologies, I couldn't hear you, ma'am.
Western Cape abstains.
Thank you. One. There's not enough votes to support, Chair. The amendment was not agreed to. Chairperson, we'll now vote on clause 8, subsection 4. Members can seek clarity.
Any comment? None. Ms. Grootboom.
Yes, Chairperson. A comment on the proposed clause 4 or sub-clause 4. Chair, with regards to this proposal, it is a similar manner that what I discussed before. The matters associated with this appeal will be prescribed in the regulations. The minister will determine the manner and the procedure, and this matters regarding legal representation would also be included there, if that is what the department is envisaging. Sometimes informal process is envisaged when legal representation may delay the process, but it would be better for the minister to determine when the regulations is made, which process would be better in this appeal, in the appeal process, Chairperson. That's my view.
Okay. Department. or if there is a legal advisor, because during the day we had another legal advisor.
Yes, Chair, it's Busiso here from the department.
Oh, okay.
Yes. No, Chair, we support the proposed amendment to include the aspect of representation. Representation is a standard requirement and is consistent with PAJA and the Constitution. We are also allied with the state law advisor to say, even though we acknowledge this aspect, it can be covered either in the Act or in the regulations. But we support the proposal that the aspect of representation must be recognized.
Okay. DDG, are you fine?
Yes, Chairperson. Busiso is our legal advisor in the department, so he has covered it. Thank you.
Okay.
Thank you.
Aska?
Thank you, Chair. We'll call a vote on subsection 4, Eastern Cape, Free State.
Support now.
Gauteng.
Gauteng support.
KZN.
Sorry, no. KZN support. Aska, thank you.
Limpopo. Not on the platform. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Support.
Western Cape.
Abstain.
Chairperson, we do not have a majority on this amendment, so therefore it is not accepted, Chairperson. 32B. Discussions, questions of clarity.
Any member who would like to say something on this? None? Let me give to the legal advisors. Are you still in the meeting, Ms. Rodboom? Or let me give to the department.
Sorry, Chairperson, it's just my computer was giving me a problem there. Yes, Chairperson, this is with regards to this is a very substantive amendment or proposed amendment. It raises some financial consequences, structural things, and so forth. So first I wanted to say that, but it is also a matter that is related to the appeal process that is envisaged in this clause, Chairperson, which is something, of course, that will have to be prescribed by the minister, because it says the manner and the procedure. So this particular deals with the manner. It provides for appeal board, a composition, and for membership. Yes, Chair, from the state law advisor's perspective, we don't think this is advisable, Chair, as it bringing other consequences that where the Minister of Finance would have had to give some prior input. It's a policy matter. So it's something that would be best decided by the Minister, him or herself, on what the proper manner would be for this appeal to be heard. Maybe there's already staff in the minister's office and so forth, maybe. So there's certainly a matter which, in our view, should be be given to the minister to decide, Chairperson, and not itself in the bill, at this stage at least. Because it definitely brings other matters into the bill that goes beyond to what was introduced in Parliament. Chair. Thank you.
Department.
Thank you, Chair. No, from our side, we do not support the proposal to provide for an appeals board or a forum. In fact, as the department, we already have a dedicated appeals unit which deals with all appeals that are being processed in terms of the departmental legislation. We also have an appeals committee which is established in terms of which will be put in place in terms of the National Forest Act, which was amended recently by Parliament. But with the appeal committee, we are still finalizing regulations of the Forestry Act. Once the regulations are done, the appeal committee will then be set up. So it means within the department, we will have this dedicated capacity through the current appeals unit, complemented by the appeals committee established in terms of the National Forest Act. So we would propose that we really don't support this proposal. And maybe just to create linkages, maybe from this act to the National Forest Act, may include a one-liner that says, Minister may refer the appeals in terms of this act to the appeal committee established in terms of the National Forest Act, so that they are proper linkages. But the capacity is there already in terms of our appeals unit and the appeals committee, which will be established in terms of the National Forest Act. Thank you, Chair.
You, Oscar?
Thank you, Chairperson. I will then go to the voting process on 32B. Eastern Cape, either Dr. Bese or Mr. Mkiva. Free State.
Free State abstains.
Gauteng.
Gauteng abstain, Chair.
KZN.
KZN, which one is this one? Is it a Gauteng one?
Yes, 32B.
Okay, God, sorry guys. Yeah, I abstain. Thank you.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Northwest abstain.
Western Cape.
Western Cape.
Abstain.
We got a majority of abstains on this one, Chairperson. The amendment is not agreed to. The next amendment, the next mandate would be from KZN, Chair.
Honorable PB, whether she wanted to read her mandate or she wanted the Secretariat to read it.
I can have the Secretariat to read it, please. Thank you.
Thank you, Mama.
Mama.
The KZN negotiating mandate for the National Veld and Forest Amendment Bill, B24B of 2021, deliberated on the 24th of September 2023. The vote of the legislature is as follows. The Portfolio Committee on...
It's not on the
Yes. Okay, it probably means that I must stop sharing the...
Yeah.
And is it on screen now?
Yeah.
Okay. My apologies. One was a Word document and the other one is a PDF, and it didn't switch between the two. The Portfolio Committee on Conservation and Environmental Affairs met on Monday, the 4th of September 2023, and agreed to mandate the KwaZulu-Natal delegation to support the National Veld and Forest Fire Amendment Bill, B24B of 2021, with the following proposed amendments. 1. Having considered the submissions received on the clauses of the bill, the committee proposes the amendments listed below, with proposed insertions being underlined and deletions being in bold and in square brackets. 1.1. Clause 2 of the bill, definitions. The extension of the definition of fires in the open air to be inclusive of other prescribed burning activities, prescribed grass management burning, forest residue burning, conservation burning, to get rid of unwanted alien wood species. These types of control burnings need to be regulated outside of the circumstances when a warning by the Minister has been issued in terms of Section 10. 2.
Chair, we can discuss this one, this clause, and then vote on it, Chair. Chairperson?
Oscar?
We're ready
Can
to
we discuss, honorable members? Sorry for that. Hey, the network. Any seeking clarity, seeking question or comment? None. Okay. Legal advisor, Ms. Rodpo.
Thank you, Chairperson. Chairperson, this is a policy matter, and I would not give any comment on this matter and allow advocate from the department to comment on this matter, Chairperson. However, Chairperson, may I ask to be excused from the meeting? I'm not sure whether Advocate Jenkins has yet joined the meeting.
Okay, and check him whereabout.
Okay, Chair, I will find out if he can join the meetings shortly.
Please.
Thank you, Chair.
Department?
Thank you, Chair. No, from our side, we do not support the proposal to amend the definition of fire in the open air. To us, this definition is broad and covers all fire in the open and makes provision for prescribed grass management burning, forestry residue burning, and conservation burning, and so forth. So the proposal that some of the fires controlled burning should be regulated outside the ambit of Section 10.2 is not supported. The responsible persons must apply for exemption still. So, Chair, in summary, we don't support the proposal. Thank you.
Thank you very much, sir. Oscar?
Thank you, Chair. We will go to the voting on Clause 2. Eastern Cape. Free State.
Free State abstains.
Gauteng.
Gauteng abstain.
KZN.
KZN supports 20 mandate.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Abstain.
Western Cape.
Abstain.
Chairperson, we have 1, 2, 3, 4, 5 abstained. Amendment is not agreed to, Chair. Cobus, Clause 7.
For 7 of Bill, amendment of sections 26 of Act 101 of 1998. Clause A. Clause 7 has generated concerns as to the conferral of enforcement powers of search, seizure, and arrest to traditional leaders in terms of the Act. While police officers, as well as other officers designated by the Minister of Justice in terms of the Criminal Procedure Act, Act 51 of 1977, may be authorized to exercise enforcement powers, it is questioned as to whether traditional leaders should be granted such extensive powers that impact on the constitutional right to privacy. With this in mind, we suggest that the references to the traditional leaders having the power to enter, search, seize, and arrest be removed, or that traditional leaders be assisted by the police in their enforcement role if the provision still remains.
Are we going to read them all together, or are we going to vote on them individually?
Oscar, I'm going to leave.
Oh, read them all.
Chair, I can read them all. They don't all focus on the same thing, but I'll read them all, and then I think the votes might end up being point by point.
Okay.
Point B. Section 26(3) requires officers or traditional leaders exercising powers under the Act to produce on request the prescribed proof of their identity. This may prove to be problematic as it is unclear what this proof will constitute. It is preferable to rather have officers that have been trained to produce their prescribed identification card issued by the department. Point C. We also note the language of the proviso in Clause 7, provided that they have been trained. We are unsure if they is in reference to all the officers listed in Clause 7, including the police, or only traditional leaders and peace officers. This creates ambiguity in the section and must be clarified. We therefore propose the following amendments to Clause 7 to ensure that we do not confer undue powers of search, seizure, and arrest on traditional leaders in terms of the legislation and to clear up any ambiguity. 26(2)(a). A forest officer, a police officer, a peace officer, a traditional leader as defined in Section 1 of the Traditional Coins and Leadership Act deleted, and an officer appointed in terms of Section 5 or 6 of the Fire Brigade Services Act 9 of 1987, Act 99 of 1987, have the power to enforce the Act in terms of this chapter, provided that they, deleted, such officers have been trained to be competent by an accredited institution to exercise powers to enter, search, arrest, and seize in terms of the Act. B. A reference to a fire protection officer in sections 27, 28, and 29 includes the officers and the traditional leader deleted, referred to in paragraph A. 3. A fire protection officer and any other officer or traditional leader deleted, contemplated in subsection 2A, exercising powers under this Act must carry with him or her and produce on request the prescribed proof of his or her identity deleted, identification card issued by the department as a replacement, and appointment as a fire protection officer. That is the entire proposed section. Oscar, I don't know if we're going to have to break it down in 26(2) and then B and then 3.
Correct. We will, Chairperson, we will take a vote. I mean, we can discuss all of it and then we'll vote on each one, Chair.
Yes, let me check with members whether, okay. Legal advisors? I don't know.
Chairperson?
The person. Yes, Honorable Labuskakne.
Can I ask the legal advisor before in his explanation of this or any comment, if will that have the same meaning, that last sentence 3, a fire protection officer and any officer contemplated in subsection 2A exercising powers under this act must carry with him or her and produce on request the prescribed identification card issued by the department and appointed as a fire officer? Will that have the same meaning if it says that it is therefore submitted and the following be inserted after the word identity and also provide proof of competence? Is that the same kind of meaning? Is that, although it's different wording, does it mean the same thing in legal terms? And also provide proof of competence. Thank you.
Legal advisors from Parliament and the department. Let me start with Parliament if they are there in the meeting. Okay. Department.
Thank you, Chair. And honorable members, from our side, now where do I start? On the submission from KZN, we firstly do not support the removal of reference to traditional leaders. We think that traditional leaders are quite key stakeholders in relation to implementation of the Act. They are custodian of large areas of land, including communal land. So by including them expressly in the bill, this will assist us in enforcing the Act and prevent or reduce instances of Veld fires. I think we mentioned before that in terms of competency and training, the traditional leaders will undergo intense training by accredited institutions to ensure that they are fully competent in enforcing the provisions of the Act. I think that the bill is quite clear on that, to say traditional leaders must undergo that intensive training before enforcing the provisions of the Act. In terms of the issue of proof of identity, that detail will go to the regulations. The provision says identity as prescribed, so that means that the details, minister must prescribe the details in terms of how that identity will look, including the identification cards. So that kind of detail is detail that must be covered in the regulations. In respect of the proposed change from the word they, firstly, the word they in clause 7 refers to all the officers. So it is not specific only to traditional, to forest officers or officers in terms of the Fire Brigade Act, but it's all encompassing. It includes all the officers listed in that provision. However, we are agreed with the change from the wording they to such officers as proposed by KZN. Chair, I think in summary, that is our response on the various issues raised by KZN in this part. Thank you, Chair.
Thank you very much. Askam?
Thank you, Chair. I will call for the voting on clause 7A. 7A would be Eastern Cape. Not on the platform. Free State. Free State.
Jump him and we'll come back to him.
Gauteng. Gauteng. KZN.
KZN supports.
Limpopo. Not on the platform. Mpumalanga. Northern Cape.
Northern Cape would like to concur with what the explanation given by the department, not to remove traditional leaders. Therefore, we do not support the amendment.
Northwest.
Northwest, abstain.
Western Cape.
Eastern Cape abstain.
We said we'll go back to Eastern Cape. Free State.
Free State abstain.
Gauteng. Not on platform. Chairperson, not enough to sway any vote, so this amendment is not agreed to. Chair, I just need to check quorum. 1, 2, 3, 4. Okay, we're still correct. 7B chairperson would be Eastern Cape. Free State. Free State. Gauteng. Gauteng.
But they don't vote.
KZN.
KZN support.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Support.
Western Cape.
Abstain.
Free State.
Honorable Ntube, you are in the meeting.
Gauteng.
Pass.
Yeah, I think Mamgwenia's connection has been lost. Okay.
But Honorable Ntube is in the meeting. And
Yeah. But we're still correct.
Chairperson, my apologies. I can't unmute. That's why I was trying to. I couldn't unmute.
Okay.
Free State, your vote, please.
Abstain.
Okay, 7C. 7C chairperson is Eastern Cape. Free State. Gauteng. KZN.
KZN support.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Abstain.
Western Cape.
Abstain.
Free State.
Free State abstains.
Okay. Chairperson, not enough on any vote, so the amendment is not agreed to. Chairperson, KZN's mandate had further consequential amendments proposed by the province. So Kobus will read those out also, Chair.
Further consequential amendments. 2.1.1. Section 9.1 of the Act, fire danger rating. Correct the reference to the South African Weather Bureau. Oscar, I'm not sure if you want me to run through all of them.
Read them all.
2.1.2, amendments to Section 10.1b of the Act. Section 10.1 sets out the mandatory requirement for publication of warnings when the fire danger is rated high or extreme in 2 newspapers circulating in the region. The newspaper warnings might present practical challenges as weather can turn suddenly with insufficient time to publish in newspapers. The internet age also allows for quick communication via social media. Hence, we propose that Clause 10.1 be made subject to Clause 10.4, which allows the Minister to publish the warnings in such other media and employ any other means the Minister considers appropriate to ensure that it is effectively communicated. This will obviate any legal challenge if the urgency of the matter does not allow for publication in 2 newspapers. We therefore propose the following amendment to Section 10.1. Communication of fire danger rating. 1. The Minister must A. Communicate the rating of the fire danger for each region to the Fire Protection Association in that region regularly. B. When the fire danger is rated as high or extreme in any region, subject to subsection 4. Publish a warning at the earliest possible opportunity in all the main languages used in that region. I, on 3 television channels and 3 radio stations broadcasting to that region, and Roman 2 in 2 newspapers circulating in the region if time permits. 2.1.3 Amendments to Section 10.2 of the Act. There's been concern raised as to the alignment of terminology used in the Act regarding fire danger rating high or extreme, as opposed to the terminology used by South African Weather Services, which uses very dangerous or extremely dangerous, as this could create legal uncertainty. We suggest that the department use consistent terminology on fire danger rating and align the terminology across the amendment bill, section 10.2, as well as other consequential provisions in the Act that uses these words. 2.1.4 Amendments to section 12.4b of the Act, duty to maintain fire breaks. Section 12.4b must be amended to make reference to both high and extreme fire danger as set out in Section 10.2 of the Act, as it needs to be consequentially amended due to the new Clause 10.2 of the bill that allows for an exemption from the Section 10.2 warning. We therefore propose the following amendments to Section 12.4 of the Act. 12.4. An owner may not burn the fire break despite having complied with subsection 2 if A. The Fire Protection Association objects to the proposed burning, or B. A warning has been published in terms of subsection 10.1b because the fire danger is high or extreme in the region and the Minister has not issued an exemption as contemplated in section 10.2a of the Act, or, and this is subject to whichever terminology the department elects to use in relation to fire rating. Those are all the proposals under section 2. Further consequential amendments.
Thank you, Chair. The matter can be discussed.
My apology, honorable members. My network is bad. Like I said earlier, if my network is bad, honorable BB can share. Yes, can we get the comments or questions?
Okay, Oscar, I think the chairperson has got a problem of a network again.
Yeah.
Yeah, please continue.
Okay, shall I then go to the voting, Mambibi? Chair, shall I go to the
Hello?
vote? Yes, Chair.
Yes.
You back.
Yes.
What's your instruction?
Can we check any questions or any comment, and then we give to the department and legal advisor to deal with it, and then we can go back to voting process. Okay. Legal advisor?
Chairperson, I have nothing to add. I've just joined the meeting now. I'll
Okay.
let you know if there's something that I find noteworthy, but at the moment, nothing to add, ma'am. I've just gone through it. Thank you.
Okay. Department?
No, thank you, Chair. From our side, firstly, the comment on section 9.1 of the Act regarding fire danger rating, correct referencing of the South African Weather Bureau. Chair, we support that amendment, that proposed amendment. South African Weather Bureau should be changed to the South African Weather Services in both sections 9.1a of the Principal Act as well as section 11b. So we support that amendment, proposed amendment from KZN. Then with regards to proposals on section 10, the proposal to prescribe the communication methods or mediums. We do not support that proposal, Chair. We are of the view that section 10.4 of the Act is broad enough to cater for all types of mediums. The proposal from KZN seeks to restrict the mediums to those that they have listed, which to us is quite restrictive. We would rather opt for the current wording in the Principal Act because it's quite broad. It says minister may employ any other means as he or she considers appropriate to ensure that the communication is effective. So that is broad. It can include what KZN has listed in any other communication mediums. So we don't support that specific proposal. Then the comment around prescribed burning, I think we've dealt with that when we're dealing with the definition of fire in the open air. So that's covered. To say that we don't support a proposal that says some burning should be regulated outside the sections 10.2 or close to regulatory framework. So all persons must apply for exemptions because sometimes it will get difficult to mitigate the fires or to deal with the risks if some form of burnings are allowed outside the regulatory framework. Then on the duty to maintain fire breaks, I think so it's clause 12.4b. There we appreciate the concern from KZN that we must use consistent terminology. Therefore, if you check on the bill, we are using high or extreme. But then if you look at the Principal Act, the wording that is used consistently is when the fire danger is high throughout the Act. And also in the bill, I think we've used the word extreme only once in clause 10.1b. So we would support a proposal that says, let's use consistent wording, let's use higher danger, and maybe remove the word extreme because it is only used once in the context of section of clause 10. So, Chair, we support the proposal that let's use consistent wording throughout, and also the cross-referencing back to Section 10(2)A is supported as well. Chair, I think those were the issues that came from this part. Thank you, Chair.
Thank you very much, sir. Oscar?
Thank you, Chair. We will then go for a province-to-province vote on 2.1.1. Eastern, we still correct, Chair. I checked. Eastern Cape, Free State, okay, we can come back to Free State because I think still has the same problem, Chair. Gauteng is no longer on the platform.
Amen.
KZN.
KZN supports.
Limpopo. Mpumalanga. Northern Cape.
Northern Cape abstain.
Northwest.
Support.
Western Cape.
Abstains.
Free State. Mr. Mzube. He's on the platform, but I don't think he can. Okay. Chairperson, we do not have enough votes to form a majority on this amendment. Not accepted, Chair. 2.1.2 Eastern Cape. Free State. Gauteng is not on the platform. KZN.
KZN supports.
Limpopo.
What about Gauteng?
Gauteng is not on the platform, ma. Mpumalanga. Northern Cape.
Abstain.
Northwest.
Support.
Western Cape.
Abstains.
1, 2. Not enough to sway any form of a decision. So this amendment is also not agreed to. 2.1.3 Eastern Cape. Free State. Gauteng's not on the platform. KZN.
KZN supports.
Limpopo, not on the platform. Mpumalanga, not on the platform. Northern Cape.
Abstain.
Northwest.
Support.
Western Cape.
Abstains.
Enough votes on any decision on this. Amendments not agreed to. 2.1.4 Eastern Cape. Free State. Not on Gauteng's not on the platform. KZN.
KZN supports.
Limpopo not on the platform. Mpumalanga not on the platform. Northern Cape.
Abstain.
Northwest.
Support.
Western Cape.
Abstains.
The same, no, not enough votes on any decision. The amendment is not agreed to. Chairperson, we've come to the end. No, there is still more for KZN, but I think it, Kobus, can you just read it out, please?
New amendments are also proposed for consideration by the department and report to the province.
Chairperson, if I may, this part of the mandate merely compels the department to report to the province on this. We do not have to take a vote on this, Chairperson. The province requests a report from the department. Thank you, Chair.
Thank you very much.
A. The inclusion of prescribed burning where fire is used as a land management tool as a provision in the Act outside of Section 10.2 warnings. This will create an enforcement mechanism to hold landowners accountable and prevent the spread of fire even where no fire danger warning has been issued. A fire protection association, in terms of current legislation, can only object to a fire break being burned when a warning has been issued, and hence in principle has no control over other types of prescribed fires lit when no warnings have been issued. FPAs argue that the majority of unwanted fires occur when the fire index value, or FPI, is yellow, and at times when green, when other prescribed fires in the open air are lit. B. Inclusion of a definition of vegetation, and C, the need for a revised definition of veld to be inclusive of hazardous materials and to prevent state-owned enterprises like Transnet and Eskom evading their responsibilities in terms of the Act due to their argument that their property is not defined as veld. Point 4. The province further requests clarity from the department on the following issues raised by the public and require a report back to this committee. Clause 7 of the Bill, 4.1, conferral of powers to search, seize, and arrest on traditional leaders and peace officers, and clarity on how this will be effected. 4.2, Clause 7 of the Bill, training of traditional leaders. Clarity-seeking questions were raised on the practicalities regarding the training of traditional leaders, as well as to which accredited agencies would be used. Some communities questioned whether there were any such agencies in the rural districts in which they were situated. Others advocated the use of accredited agencies from within their districts. Questions relating to the cost of the training was also raised at the public hearings. Was it government or the traditional leaders themselves who would bear such training costs? The department to respond on the issues raised. 4.3, Clause 3 of the Bill, Minister's opinion. There were clarity-seeking questions on what would inform the Minister's opinion in Clause 3 of the Bill that a fire protection association is required. There was also a request for clarity around the process of approaching the minister if the public was of the view that the minister should exercise this power. Clarity was also sought as to whether this will only be done when there is no existing fire protection association formed for that area. Department to respond on the issues raised. 4.4, lack of firefighting equipment, resources, and capacity challenges. The lack of firefighting resources and equipment to service the vast rural areas in KwaZulu-Natal, as well as capacity challenges in fighting fires, were recurring concerns at all public hearings, and the public requested clarity on how this will be addressed. 4.5, clarity as to why there was no imposition of penalties where an organ of state fails to comply with Clause 4 of the Bill. How will these organs of state be held to account? 4.6, clarity on the respective roles of the fire protection officer vis-a-vis traditional leaders and their need to work together. And 4.7, clarity on the nature of the prescribed proof of identity in Clause 7 of the bill. 4.8, with the sugar industry being an important industry in the province, the committee seeks further clarity from the department as to whether this bill will have any detrimental impact on the controlled burning of sugarcane and correspondingly the sugarcane industry. That is the last of the points raised by the province for clarity and also the end of the mandate.
The next mandate would be the Limpopo chairperson.
Can you read it? Ask Govas.
The Limpopo Legislature negotiating mandate on the National Health and Forest Fire Amendment Bill, Bill B24B of 2021. 24 September 2023 was the date of deliberation. The vote of the legislature, the provincial NCOP permanent delegates to negotiate in favour of the bill with the proposed amendments. Proposed amendments. First Amendment, Clause 7, Amendment of Section 26 of the Act 101 of 1998. Section 26(2) and 3 should include a member of an association established in terms of the Communal Property Associations Act 28 of 1996. Proposed additions. Oscar, I don't know if you want me to read them all or stop, because the next point is not related to the first, but is also Clause 7. Chair?
I would say just read it all.
Let me check whether the members they want to ask question or they have any comments so that I can give to the department and legal advisors to say something. None? Legal advisor? And after the department can come in.
Yeah, now as I understand it, the department will provide the clarity for the questions asked, but nothing from my side. Thank you, ma'am.
Department?
No, thank you, Chair. From our side, I think the proposals there from Limpopo are related in all those 26, 2 and 3 and the insertions that they are making there. But basically, from our side, we do not support the proposal to make express reference to communal to associations established in terms of the Communal Property Associations Act. The current definition of owner is broad enough to cover these specific stakeholders. The Communal Property Association, in our view, should not be distinguished as a separate entity from the owners of the land. Therefore, they have every right, whether they are individual owners or in an organized fashion under a CPA, to join a fire protection association. So that's our view, Chair, to say they must as well join fire protection associations, whether as individual owners or in an organized fashion through a CPA. Thank you, Chair.
Thank you. Oscar?
Chairperson, I will call for a vote on the proposed amendment 7. and then we can go on to the 2A, the 2B, and number 3. Eastern Cape. Free State.
Abstain.
Gauteng. KZN.
Which one is that, Oscar?
Limpopo,
Which one is that?
Clause 7.
Okay, abstain, put it.
Abstain.
Yes.
Limpopo, not on the platform. Mpumalanga, not on the platform. Northern Cape.
Abstain.
Northwest.
Abstain.
Western Cape.
Eastern Cape abstain.
Chair, then 2A, Quibus.
2A. A forest officer, a police officer, a peace officer.
Chairperson.
Hello.
It's Mlindi Nana.
Honorable Nana. Yes, Honorable Nana.
I had asked calling for the Eastern Cape and there was no reply. I just want to place it on record. I'm in the meeting, but Dr. Bessa was supposed to be sitting in the meeting. I mean, I know he has been in the meeting so that he then cast our vote. Thank you. I just wanted to place that on record that I'm in the meeting.
Yes. Yes, I'm aware that you are in the meeting, and Honorable Kiva also, he is in the meeting. Maybe it's because you don't have the mandate. I don't know. That's why you they are quiet. I don't know. But thank you very much for putting in record that you are in the meeting, Honorable Nana. You can continue, Oscar.
What was 2A?
I'll start 2A again. 2A. A forest officer, a police officer, a peace officer, a traditional leader as defined in Section 1 of the Traditional and Khoisan Leadership Act, a member of an association established in terms of the Communal Property Associations Act 28 of 1996, and an officer appointed in terms of Section 5 or 6 of the Fire Brigade Services Act of 1987, Act number 99 of 1987, have the power to enforce the Act in terms of this chapter, provided that they have been trained to be competent by an accredited institution to exercise powers to enter, search, arrest, and seize in terms of the Act. That was 2A. Oscar, do you want me to read B as well? And then we finish the reading of 2? Because B is just a short one.
Yeah.
2B. A reference to fire protection officer in sections 27, 28, and 29 includes the officers, the traditional leader, and a member of an association referred to in paragraph A. That is proposal 2.
Yeah, we can. Members are free to discuss those 2.
Discussion? Members, any question? None. Let me give to legal advisors to comment and the department will follow.
No, ma'am, no comment from legal services. Thanks, ma'am.
Thank you. Department, legal advisor from the department.
Oh, thank you, Chair. In my response to the first item, I think I covered all those items to say we don't support the inclusion of the reference to the associations.
Okay.
So that I will stick with that response, Chair. Thank you.
Thank you. Pascal?
Thank you, Chair. We're going to vote on 2A, Eastern Cape. Free State.
Abstain, Free State.
Gauteng is not on the platform. KZN.
KZN abstain.
Limpopo is not on the platform. Mpumalanga, not on the platform. Northern Cape.
Abstain.
Northwest.
Abstain. Abstain.
Western Cape.
Abstain.
Then 2B, Eastern Cape. Free State.
Free State abstain.
Gauteng's not on the platform. KZN.
KZN abstain.
Limpopo, not on the platform. Mpumalanga, not on the platform. Northern Cape.
Abstain.
Northwest.
Abstain.
Western Cape.
Abstain.
Chair, on all those ones we voted on, there's not enough on any decision. So the amendment is not agreed to. The last one, Cobus, number 3.
E. A fire protection officer and any officer or traditional leader or member of an association contemplated in subsection 2A exercising powers under this act must carry with him or her and produce on request the prescribed proof of his or her identity and an appointment as a fire protection officer.
Okay. Discussion? None. Legal advisors?
All good, thanks, ma'am.
Department?
Thank you, Chair. We don't support the proposal to amend 26(2) to include the association as stated before, Chair. Thank you.
Thank you. Pascal?
Thank you, Chair. I'll call for the vote on 3. Eastern Cape. Free State.
Free State abstain.
Gauteng's not on the platform. KZN.
KZN abstain.
Limpopo's not on the platform. Mpumalanga, not on the platform. Northern Cape.
Abstain.
Northwest. Northwest.
Abstain.
Western Cape.
Abstain.
Thank you, Chair. That is the end of the amendments for the Limpopo mandate. The next mandate would be Mpumalanga.
Chair, I'm assuming I'm reading this one. I'll carry on with it. Negotiating mandate on the Veld and Forest Fire Amendment Bill from Mpumalanga Province, deliberated on the 13th of September 2023. The vote of the legislature is as follows. The Portfolio Committee on Agriculture, Rural Development, Land and Environmental Affairs, after considering the National Veld and Forest Fire Amendment Bill B24B of 2021, confers on a permanent delegate representing Mpumalanga Province in the NCOP a mandate to negotiate in favour of the bill. There is no proposed amendments.
Next province?
Northern Cape, Chair.
Mam Kausa, because I don't know where you'll be able to read, because, or Secretariat can read on your behalf.
I request a secretariat. Thanks, Chair.
Sure. Gobas?
Northern Cape Negotiating Mandate, National Veld and Forest Fire Amendment Bill, B24B of 2021. The date of deliberation was Friday, the 15th of September 2023, and the vote of the legislature is the legislature votes in favour of the bill. No proposed amendments, Chair.
Next province would be Northwest.
I'll request Gobas to read it on my behalf.
Negotiating mandate for Northwest Province on the National Veld and Forest Fire Amendment Bill, B24B of 2021. The vote of the legislature is the Portfolio Committee on Economic Development, Environment, Tourism, Agriculture and Rural Development votes in favour of the National Veld and Forest Fire Amendment Bill with proposed amendments. The proposed amendments are as follows. 1. The definition of fire in the open air as per the new insertion sounds restrictive, as it excludes fire not within the building or structures in the specifically designated for such fire. It is proposed that the initial definition be maintained to also include fires that occurs in household and existing structure, as it limits the scope of fire protection association structures when such disasters occurs. That's the first proposed amendment, Chair.
Any question? None? Legal advisor, can you assist if there is something that you want?
No, I'm looking at it now, ma'am. I'm thinking that this would take the bill to a position where we're now dealing with domestic fires. I don't, let's hear what the department says. I don't really have anything to add, but I wouldn't support this amendment unless I really go into it. I think this might change the scope and the application of the bill, ma'am. Thanks.
Thank you. Department.
Thank you, Chair. From our side, we do not support the proposal. These types of fires, for example, fires that occur in households and related structures fall outside the ambit of the Act. They are regulated under the Fire Brigade Services Act, so we don't support the proposal from the Northwest. Thank you, Chair.
Hey, thank you. Aska. Aska?
Sorry, my computer was a bit crazy. We will vote on the first one, Chair. Eastern Cape. Free State.
Abstain.
Gauteng's not on the platform. KZN.
KZN abstain.
Limpopo's not on the platform. Mpumalanga's not on the platform. Northern Cape.
Abstain.
Northwest.
Northwest, my mandate. I support.
Western Cape.
Abstain.
Okay, there's not enough votes to concur any decision. The amendment is not accepted. Number 2.
2. The bill seeks to compel municipalities, state-owned enterprises, public entities, or other state organs which owns land to join fire protection associations. However, it does not provide for punitive measures when the latter decline to join or register or does not pay affiliation fee. It is therefore proposed that the associations be given authority to monitor non-compliance in accordance with sanctions that should be codified. That's point 2, Chair.
Any discussion? Questions? Legal advisor?
Ma'am, on the question of penalties, it looks like criminal penalties for non-joining. I would say that that's not appropriate because these are administrative matters. There are other ways of ensuring that there is compliance, but certainly the way that it's written now, that it's required to join one of those firefighting institutions is correct. That's how we usually do it in legislation. You can't force it with a criminal. That would be an overreach. So from a legal side, ma'am, I do not support criminal penalties for non-compliance with administrative issues set out in this bill. Thank you, ma'am.
Thank you. Department?
Thank you, Chair. We are fully aligned with the state law advisor on this one. And offences and penalties are already covered under section 24 and 25 of the Act, of the Principal Act. And the wording of those two provisions is quite broad as well. It says, any person who contravenes the provision of the Act, this would be include a natural and juristic person. So it also says any owner. So that could be quite broad as well to include owners in the form of a company or private persons. But we don't support the criminal aspect as stated by the state law advisor. Thank you, Chair.
Thank you. Pascal?
Thank you, Chair. I just wanted to make a correction there. It is not the state law advisor, it's the parliamentary law advisor, Advocate Jenkins. Thank you, Chair.
Okay.
The number 2, we will do a vote. Chairperson, Eastern Cape. Free State.
Abstain.
Gauteng's not on the platform. KZN. KZN. Bambibi. Okay, we can come.
Which one is that one? Abstain.
Number 2.
Number 2. Oh, no, abstain, Puti.
Limpopo, not on the platform. Mpumalanga, not on the platform. Northern Cape.
Abstain.
Northwest.
Support.
Western Cape.
Abstain.
Not enough votes for any decision. Amendment not agreed to. Number 3.
Point 3. All disaster services must be centralized to ensure coherence.
Any discussion, question? Legal advisor?
No comments from this side, ma'am. That's a policy matter. Thanks.
Department?
Thank you, Chair. No, from our side, this we read this number 3 to be a general commentary, and no, it doesn't really propose any specific amendment to any specific provision. So on this one, we don't support I mean, we are really constrained because it doesn't really propose any amendment.
Okay.
Thank you, Chair.
It means there is no amendment.
Yeah,
Next,
number
next
4.
one.
This one we can skip as a comment.
4. Though the bill requires the formation of FPA and to improve administration of the Act, the current conditions of state-owned farms and traditional land are not in good condition. As a result, are not in compliance. Fire belt, shortage of water. Furthermore, the bill does address compliance model prior to the allocation of state farms. As a result, the burden will eventually be upon the lessee, who will be expected to ensure that the property complies with the requirement of the Act. It is therefore suggested that FPAs and disaster management units should form part of state allocation committee to ensure expected compliance. Consequently, compliance certificate must be ensured. I believe that's a recommendation as well, but we'll leave it to the rest.
Okay.
Would you like me to read 5? I just need confirmation that 4 was a recommendation, but I'll read 5 if there's no complaints.
Are we going to vote on 4 or are we going to... Yeah, let's vote on 4 first. Chair, your decision.
But it's a resolution. Is it not an amendment or?
That's for the legal advisors to say.
Oh, okay. Legal advisor, can you assist?
It appears, ma'am, that what they're suggesting is the membership to the disaster management units. So from the state allocation committee. So the question that we must, and it's probably more of a policy issue, the department can respond to it, is should we change the composition of that committee to ensure that the expected compliance, that there's compliance? That's how I understand the comments, ma'am. But they don't. It's not very specific. Leave it at that, ma'am. See what the department says.
Department.
No, thank you, Chair. No, from my side, the issue of state-owned farms, I mean, should fall under the either the Department of Public Works or Department of Agriculture, Land and Rural Development. It's really not an aspect that must be addressed in this bill. In particular, the aspect of the State Allocation Committee that should fall in either in those 2 departments. So would not really have influence on how the State Allocation Committees should be formulated. But from our side, we do not support the proposal. Thank you.
Thank you, Oscar.
Okay, Eastern Cape. We will be voting on number 4. Eastern Cape. Free State. Free State.
You'll come back to him.
Abstain, Free State.
Oh.
Gauteng is not on the platform. KZN.
KZN abstain, Chairperson.
Limpopo is not on the platform. Mpumalanga is not on the platform. Northern Cape.
Abstain.
Northwest.
Support.
Western Cape.
Abstains.
Not enough votes to support any decision. Amendments not agreed to. Number 5.
5. The state, as the custodian of the land, must be compelled by the bill to provide support to farmers who are already in long-term lease agreement to ensure compliance with the amendments.
Any comment? Legal advisor?
Ma'am, again, this is a policy matter and it depends on the budget. And I don't know how much, what is required to ensure that there is compliance. But I would think this has to do with what's the financial implications of this piece of legislation. And if this has not been factored into the CS, into the socioeconomic impact assessment, then it won't be the right time to accept this kind of a proposal, ma'am. Thanks.
Thank you. Department?
Thank you, Chair. On this one, support to farmers is the domain of DALRAD, the Department of Agriculture, Land Reform and Rural Development. So we really don't have a comment on this one.
Okay, thank you.
Yeah,
Oscar?
okay. Right, we'll vote on 5. Eastern Cape. Free State.
Abstaining.
Gauteng's not on the platform. KZN.
KZN abstain, Chairperson.
Limpopo's not on the platform. Mpumalanga's not on the platform. Northern Cape.
Abstain.
Northwest.
Support.
Western Cape.
Abstain.
Not enough votes for any decision to be taken. Amendment not agreed to. Number 6.
Point 6. The Northwest Province is regarded as a rural agrarian province with approximately 60% of the population living in the rural areas. Furthermore, a large portion of the Northwest Province farms are still registered in the name of the Republic of Botswana, which does not exist anymore. Even those that are registered under the local municipality are registered outside demarcation of same municipalities. Proposal is that the bill to address must be made available to all the FPAs for a period of 6 months, providing with targets regarding compliance issues. Consequently, the FPA from respective provinces will ensure that all outstanding documents and compliance matters are addressed and completed.
Any comment? Legal advisors?
I have no comment on this one, ma'am.
Department?
Thank you.
Thank you, Chair. From our side, the issue of registration of farms or incorrect registration, registration outside demarcations is really not our domain. I think should be referred to the relevant departments. But we're struggling to grapple with the last paragraph of that, the last part of that paragraph, Chair. So, thank you, Chair.
Thank you. Oscar?
Thank you, Chair. The vote on 6 would be Eastern Cape. Free State.
Abstained.
Gauteng's not on the platform. KZN.
KZN abstain.
Limpopo and Mpumalanga both still not on the platform. Northern Cape.
Abstain.
Northwest.
Support.
Western Cape.
Abstain.
Chairperson, not enough votes for any decision to be taken. The amendment not agreed to. Number 7.
Point 7. Both the Act and the bill fails to recognize the advanced technology to control fire, as more often, if the fire intensity is infuriated towards the entrance that has to be contained, it is difficult to do so. Hence, it is proposed to consider new technologies.
Any comment? None. Legal advisor?
No comment from my side, ma'am. Thank you.
Thank you very much. Department.
No, thank you, Chair. On this one, I think we acknowledge the proposal for us to consider the aspect of advancements in technology. I think it's a good proposal, but we should be dealing with it at the implementation level. And I think we acknowledge this proposal, Chair, from our side. But it does not really translate to any concrete proposal for us to amend the bill in its current form. Thank you, Chair.
Thank you, Oscar.
Vote on number 7, Eastern Cape. Free State.
Free State abstains. Free State abstain.
Gauteng's not on the platform. KZN.
KZN abstain.
Limpopo and Mpumalanga is not on the platform. Northern Cape.
Abstains.
Northwest.
Support.
Western Cape.
Abstain.
Chair, not enough votes for any decision to be taken. Amendment not agreed to. Number 8.
There should be a clause where the Department of Forestry, Fisheries and Environment should look into why there are prevalent wildfires in the province, especially in Kagiso, Kagiso, Molopo. The bill must give a clause that the disaster management should make provision for drought and forest fire services and centralization of services, as they can wait for more than 5 days for the disaster service.
Next.
Any comment? Bibi, Mama. Any comment?
No comment. No comment. Say I'm stuck here.
Legal advisor.
No comment. Thank you, ma'am.
Department.
No, thank you, Chair. No, from our side, we note the submission, and I think there is Notot is making a valid point to say, let's look, maybe study the areas where fires are most prevalent and maybe propose interventions. But that will be our ongoing work in terms of providing continuous support to the FPAs and the relevant parties in enforcing the provisions of the Act. But I think there is a point in us then looking at if there's prevalent fires in a specific area, there is a need maybe to commission a study to check what may be the causes, and for that study to then make recommendations in terms of proposed solutions and interventions from our part. Thank you, Chair.
Thank you very much, sir. Oscar.
Thank you, Chair. We will. Number 8. Call a vote on number 8. Eastern Cape. Free State.
Abstain. Free State.
Gauteng's not on the platform. KZN.
KZN abstain.
Limpopo, Mpumalanga is also still not on the platform. Northern Cape. Northern Cape.
Abstain.
Northwest.
Support.
Western Cape.
Abstained.
Not enough votes to effect any decision. Amendment not agreed to. Number 9.
9. The bill must expressly prioritize farmers on working on fire program as opposed to the EPWP that has a contrary mandate than working on fire program.
Comment? Legal advisor?
And this is a policy matter, no comments from my side. Thank you, ma'am.
Thank you. Department?
No, thank you, Chair.
Department?
Yes, Chair. From our side, we don't think there should be a differentiation between the Working on Fire program and the EPWP programs. Those are all collectively government programs. Instead of pushing for a differentiation, let's rather maybe harness all the resources that are available to make sure that we combat veld and forest fires. So both programs are government programs which must be supported and implemented to the latter. Thank you.
Thank you.
Okay, we'll vote on number 9. Eastern Cape. Free State.
Abstain, Free State.
Gauteng's not on the platform. KZN.
KZN abstain.
Limpopo and Mpumalanga still not on the platform. Northern Cape.
Abstain.
Northwest.
Support.
Western Cape.
Abstain.
Chair, not enough votes to concede any decision. Amendment not agreed to. Number 10.
It is proposed that workshops and awareness has to be made in schools so that learners must be exposed into knowing how to take care of the environment and to prevent future disasters caused by veld and forest fires.
Is this an amendment? Oops.
Comment? Legal advisor?
Sorry, ma'am. Yes, that's obviously a very good suggestion, but it's not for this piece of legislation to include that. It has to do with what happens in schools. It's a completely different department. But let's hear from the department, ma'am. Thank you.
Thank you very much, sir. Department?
No, thank you, Chair. On this one, yes, it is a good proposal, but not for incorporation into the bill. In fact, the department does have a support strategy that caters for, in particular, the forestry aspects, but they maybe need to extend that strategy, to extend the ambit of that strategy to also look into matters of veld and forest fires. And part of that strategy includes the aspect of advocacy and education. So I think this can be pursued within the confines of the support strategy. Thank you, Chair.
Thank you very much, sir. Aska?
Chair, we will vote on number 10. Eastern Cape. Free State.
Abstain.
Gauteng's not on the platform. KZN. KZN. Hello. KZN. Okay, we'll come back. Limpopo, Mpumalanga is not on the platform. Northern Cape.
Abstain.
Northwest.
Support.
Western Cape.
Abstain.
KZN. Okay, no vote from KZN.
Abstain.
Thank you. Number 11.
The bill does not give recourse in case of a disaster to traditional authority who are owners of the communal land as compared to private landowners and beneficiaries state.
Thank you. Legal advisor?
No, this is a policy matter, ma'am. I don't have any comment on this.
Department?
Chair, from our side, disasters fall under the Disaster Management Act as administered by COGTA. But then in terms of our legislation, recourse, if one is aggrieved, applies to everyone who is aggrieved without discrimination. So we would really dispute a proposition that says the act is discriminating against traditional authorities. Thank you, Chair.
Thank you.
Okay, we'll vote on the last one. Eastern Cape. Free State.
Abstaining.
Gauteng's not on the platform. KZN. KZN. Okay, Limpopo's not on the platform. Mpumalanga's not on the platform. Northern Cape.
Abstain.
Northwest.
Agreed.
Western Cape.
Abstain.
KZN.
KZN agreed. Bible.
Okay. You support, okay. Thank you. Chairperson, there is not enough votes to concede any decision. Agree. Amendment not agreed to. We're now down to the last mandate, Chair, which is the Western Cape.
Honorable Labaskakni, I don't know whether you would like to read or ask.
This is reading so
Secretariat.
nice. Would he mind to read the Western Capes as well?
No problem. The Western Cape Provinces Standing Committee on Agriculture, Environmental Affairs and Development Planning, having considered the subject of the National Falcon Forest Amendment Bill B24B 2021 NCOP, referred to it in accordance with Standing Rule 217, conferred on the Western Cape delegation in the NCOP the authority to support the bill. The committee further proposes the following amendments. Number 1, grammatical. 1.1. Long title, last line. It is submitted that the word matter be replaced with the word matters. Chair, I don't know if I should read the entire one. It all focuses on grammatical issues, so they are all short proposals.
No, can you read 111? Okay. Any comment? Legal advisor?
Thanks, ma'am. It sounds like it appears to a rational suggestion, ma'am, to have it matters rather than matter. Thank you.
Department?
Chairperson.
Thanks.
Department?
The proposal is supported, Chair. Thank you.
Chairperson?
Yes, ma'am.
Can I make a proposal from on the Western Cape one? The proposals on the grammatical 1.1 until 1.6. Can the department just give us an indication whether it's if they agree to make these, because it's really not something substantial, and then move to the substantial amendments.
Okay.
Do we really have to vote on all these things?
Chairperson, if the Western Cape delegate agrees, we can take. In this instance, it's all grammatical. It's minor. We can take them all one shot. The department can agree on all of them, and then we can vote on all of them if the delegate agrees with that.
I'm absolutely fine with that. Thank you.
Okay. Continuing with grammatical proposals, 1.2, clause 2b, definition of municipality. It is submitted that the word system be replaced with the word systems. 1.3, clause 3, amendment of section 3 of the Principal Act. It is submitted that on page 3, line 19, the space be inserted before the word established. 1.4, clause 4, amendment of section 4 of the Principal Act. It is submitted that on page 3, line 33, the year 2021 be replaced with 2023. 1.5, clause 6, amendment of section 11 of the Principal Act. The term department on page 3, line 51, apologies, refers to the national department which has responsibility for the management of Veld fires. As per the Principal Act, and not the department responsible for the administration of the South African Weather Services Act 2001, Act 8 of 2001. It is therefore submitted that the first letter of the word department be a lowercase letter. Short title and commencement. It is submitted that on page 4, line 34, the year 2021 be replaced with 2023.
Thank you. Legal advisors.
Ma'am, the last one on the amendment to clause 6. I'm going to defer to the department. I don't have the whole text in front of me, but all the others are purely textual and needs to be done. We need to correct those. So I would agree with all 1.1 to 1.4, 1.5. I defer to the department because of what I said just now. Thanks, ma'am.
Thank you, department.
Thank you, Chair. From our side, 1.1 is supported, 1.2 and 3 are supported, 1.4 is supported. However, that amendment will be done by CRIDA. It is not done through an A-list process. It will be done by Parliament when the bill is being processed for at a later stage. Then 1.5, we agree with the proposal to use the small caps when referencing the department. However, in the first part, the Act does not state what is stated. The Act doesn't say national department which has responsibility for the management of fires. It clearly states that the department is responsible for administration of the South African Weather Services Act. So, Chair, on 1.5, we support the change from the word department to be in small caps. Thank you, sir.
Thank you.
Okay.
Oscar?
Okay, Chair. So the department basically agrees to everything on 1.1 to 1. They haven't spoken of 1.6. Department
Okay.
1.6.
Oh, sorry, may you please go down a bit? I want to say there. Yes, even that one, we support it, but then it will be done by CRIDA.
Okay.
Yes, thank you.
Chairperson, so we'll vote 1.1,
Yes.
1.6, all in one. Eastern Cape, not hearing.
Right. Abstaining, Free State.
Free State abstain. Gauteng's not on the platform. KZN.
KZN abstain.
Limpopo, not on the platform. Mpumalanga, not on the platform. Northern Cape.
Support.
Northwest.
Not support.
Northwest support.
Not
Sorry,
support.
not support. Not support. My apologies. You're breaking up a bit there. Not support. Western Cape.
Support.
Okay, so we do not have enough on any decision. Amendments not agreed to. Go down to 2.1.
2.1, Clause 4, Amendment of Section 4 of the Principal Act. The proposed Section 4.8 states that 8. The owner in respect of state land, a state-owned enterprise or public entity or an organ of state must within a year after the commencement of the National Veld and Forest Fire Amendment Act of 2021 join any registered fire protection association registered in the area in which the land lies is situated. It is submitted that the wording be revised as follows. Join a fire protection association if such an association has been registered in the area in which the land is situated.
Okay. Comment? Legal advisors?
I have a comment on that one, ma'am. I don't think I think the wording as it is good enough. So I'll defer to the department. Thank you.
Department?
Thank you, Chair. No, from my side, we do not support the proposed amendments. In fact, the proposed amendments seek to create discretion and make it optional for these stakeholders to join fire protection associations. The bill is quite clear. All these stakeholders must join the association, the FPAs, at all relevant times. If an FPA happens not to be in place at any given point, then there must be an obligation for the owners to create one, to create and join one. So this proposal is creating some level of discretion, whereas the Act is quite peremptory and clear in terms of what is required of owners. Thank you, Chair.
Thank you. Oscar?
Thank you, Chair. We can call for a vote on 2.1. Eastern Cape. Free State.
Abstain, Free State.
Gauteng is not on the platform. KZN.
KZN abstain, Chairperson.
Limpopo and Mpumalanga is not on the platform. Northern Cape.
Abstain.
Northwest.
Abstain.
Western Cape.
Support.
Chair, not enough to concede any decision. 2.1 amendment not agreed to. 2.2.
Clause 2.2, Clause 9, substitution of Section 37 of the Principal Act. Given that the short title of the Principal Act will be changed to the National Veld Fire Act, it is submitted that the short title of the amendment will be changed to the National Veld Fire Amendment Act 2023.
Comment? Legal advisor?
I don't have a comment on that, ma'am. It's the name of the bill. It could be name of any rose, as Shakespeare used to say.
Thank you very much, sir. Department?
No, thank you, Chair. Yeah, from my side, the bill will be processed as the National Veld and Forest Fire Amendment Bill. Then any subsequent amendments will then make reference to the updated name. So the name will be processed as is. Then further subsequent amendments will then reference the correct name. Thank you.
Thank you very much.
I mean the updated name.
Oscar?
Chairperson, 2.2. Voting commences. Eastern Cape. Free State.
Abstain, Free State.
Gauteng's not on the platform. KZN. KZN.
No. KZN abstain. Hawimma.
Limpopo and Mpumalanga is not on the platform. Northern Cape.
Abstain.
Northwest.
Don't support.
Not support. Western Cape.
Support.
Okay, Chair. Not enough votes to concede any decision. Amendment not agreed to. 2.3.
Clause 7, amendment of Section 26 of the Principal Act. In terms of the proposed amendments to Section 26(2)(a) of the Principal Act, various persons, including traditional leaders, are given the power to enforce the Principal Act. Concerns expressed relating to the powers allocated to traditional leaders to enter, search, arrest, and seize. It should be noted that these powers may only be exercised by traditional leaders provided that they have been trained to be competent by an accredited institution. It is submitted that those exercising these powers not only provide proof of their identity, but that they also provide proof of competence in terms of the Act. It is therefore submitted that on page 4, line 14, the following be inserted after the word identity, and also provide proof of competence.
Comment? Any comments or questions? Legal advisor?
Thank you, ma'am. I don't see anything wrong with the proposal, but it's certainly not necessary because where there's a search, seizure, or arrest, you have to identify yourself and you will have to show why you are empowered, or in terms of what act are you empowered to exercise your powers. So that's my comment. Thanks.
Thank you. Department?
Thank you, Chair. No, from my side, the proposal is not supported. I think earlier we really explained that why traditional leaders should be empowered to enforce the Act. We explained that in detail. But in respect of the aspect of accreditation and competence, we've also explained that to say the department will develop regulations as required by the bill, and in the regulations will also specify the necessary requirements for identification, including the how that identification card should look. That card will then be issued only to persons who have undergone the accredited training as required by the Act. Thank you.
Thank you very much. Aska?
Thank you, Chair. We will go for a vote on 2.3. Eastern Cape. Nothing. Free State.
Abstain, Free State.
Gauteng's not on the platform. KZN.
KZN abstain.
Limpopo, Mpumalanga not on the platform. Northern Cape.
Abstain.
Northwest.
Not support.
Not support. Western Cape. Western Cape.
Support.
Okay, thank you. Not enough decisions to affect any. Not enough votes to affect any decision. 2.3 amendment not agreed to. Number 3, the final one for Western Cape.
General, it is submitted that the definition of state land in the Principal Act be reconsidered to include land belonging to local authorities.
department.
Legal advisor?
Ma'am, I'm going to defer to the department. I think in any case it would include land that belongs to local authorities, but I'll have to check again. But I'll defer to the department on this one, ma'am. Thanks.
Department?
No, thank you, Chair. On this one, we do not support the proposal. To us, it appears to be a substantial amendment because it means now we need to confer with Dalrat or Department of Land Affairs in terms of what would be the suitable definition of state land, other than what is provided for in the Act, the Principal Act. So we do not support the proposal, Chair. Thank you.
Oscar?
Thank you, Chair. We will vote on number 3. Eastern Cape. Free State.
We're abstaining as Free State.
Gauteng's not on the platform. KZN. KZN. Limpopo is not on the platform.
KZN abstain.
Thank you. Limpopo, Mpumalanga still not on the platform. Northern Cape.
Abstain.
Northwest.
Not support.
Western Cape.
Support.
Thank you. Chair, not any votes to support any decision. Amendment not agreed to. Chairperson, that brings us to the end of all the mandates on both bills. All that is left over is for the members of the committee to stay behind so we can adopt the international agreement and the one outstanding minutes. The international agreement has to be adopted because it is due in the House in the week, tomorrow, I think, or Thursday. Thank you.
Thank you. Let me take this opportunity to thank department and also legal advisors that been assisting us or guiding us how to deal with this bill. Thank you very much, the department. Now you are released, and the legal advisor, you are released. Thank you.
Thank you, ma'am. Thank you. Bye.
Bye.
Okay.
Thank you, Chair.
Chair. Chair is Honorable Abiskafni.
Oh, Honorable Abiskafni.
How long are we going to be? Because I already had to be in the meeting at 6 o'clock. It's 6:15. How long is this gospel going to be?
We're just going to adopt 2 things and then we're done.
2 minutes. I think.
Minutes and a report. We can start with the important one, the report.
The report,
Can
yes.
we start with the report? Because I doubt it if I can adopt the minutes because I most probably wasn't in the meeting.
You were in the meeting. Okay, I'll read it out. It is the report of the Select Committee on Land Reform, Environment, Mineral Resource, Energy on the ratification of the amended Convention on the Physical Protection of Nuclear Material, tabled in terms of Section 2312 of the Constitution, 1996, and the explanatory memorandum attached thereto, 26 September 2023. The Select Committee on Land Reform, Environment, Mineral Resources and Energy, having considered the request for approval by Parliament for the ratification of the amended Convention on the Physical Protection of Nuclear Material, tabled in terms of Section 2312 of the Constitution and explanatory memorandum attached thereto, referred to it on the 21st of August, was briefed by the department On 5 September, the committee welcomed the detailed presentation by the department inquiring as to any deadline for the ratification of the agreement and for a list of countries party to the agreement and indicating which of them have ratified the agreement. The committee further inquired whether South Africa has experienced any form of cyber attack on any of its nuclear facilities. The department's response to the deadline of the international agreement was that the agreement has been in effect since 1996 and that no deadline existed for South Africa to ratify. It would, however, be beneficial for South Africa to ratify it as soon as possible. The department agreed to provide the committee with a list of countries party to the agreement and which of those have ratified it. The department further added that no cyber attack has taken place on any of its facilities. The committee, after deliberating the matter, recommends that the council, in terms of section 231(2) of the Constitution 1996, approves said agreement. The people.
Thank you.
So now we just need a proposer and a seconder.
Can you get a proposer and a seconder?
I move for the BP moves.
BP moves.
I second.
Mudise second. Thank you, Chair. That is the report. The minutes is also in front of, I send it to everybody. I just need someone to propose and second the minutes also, Chair.
Any proposed then second.
The minutes. Chair proposes the minutes. Second.
The minute.
Yes. PP, move for the adoption of the minutes. Thank you.
I
Thank
second.
you, Chair. Okay, so you will second, Chair. Okay. Mambibi will propose and you will second. I'll change the vote. Chairperson, we have concluded our business for the day.
Okay. Memam Kausa and Malabox Kaknik, after this meeting, can you call me quickly to discuss something urgent?
Okay.
Sure, ma'am. This takes us to the end of our meeting.
What's the secret? Why must he call you separate? What's the secret now?
What the secret? Do you want to hear what the what do you call it? The ladies talk.
It's about rank, it's about whips now.
Chairperson, is the meeting closed? Chair, is the meeting closed?
Let me take Mambi. Oh, okay. No, Mambi is fine. Let me take this opportunity to thank you all the members. This meeting is officially adjourned.
Thank you, Chair.
Thank you very much, Chairperson.
Oh, thank you, Mama. Thank you so much. Mama.